Good afternoon and welcome to the Appellate Division, First Department. We have more than 7 hours of requested argument time. So on behalf of your colleagues at the end of the calendar, I'm going to ask that you consider seeking only the time that you need, not the time that you want. Understanding we are familiar with your case, the briefs, and the record typically more than you wish we were. And know that the time that I allot is for you, not for the court. If my colleagues have additional questions beyond the light, I let the questions continue. All right. People versus Joe Lori Laubriel. Sorry about that. 3 and 1, okay. 3 and 1 and 3, and thank you. Pettinato versus EQR River Tower. Okay. All right, let's do 5 and 2, 4 and 4. Like I said, questions can probably take you to 5 anyway. Ali versus KNH Steinway. Was that one the one? Okay, so that one has been submitted. Alesco Preferred Funding versus ACP Re Limited, and this one requires all the time allotted, so give it to me.
Thank you, Your Honor. Your Honor, this court previously granted my colleague John Bash's application to appear, Roja Bishi. I would like to request permission for him to argue.
Of course, that application is granted.
We have conferred, and with Your Honor's permission, we have allocated our request as follows. Mr. Bash will argue for the tower defendants, and he'll have 6 minutes.
Okay.
I will argue for the tower group directors and officers, only 2 minutes.
Okay.
And Mr. Sorer will argue for the Garfunkel defendants for 2 minutes.
Okay.
We have requested that 3 minutes rebuttal, and Mr. Bash will handle the rebuttal for all 3 of them.
Those requests are granted. Thank you. Gentlemen?
Your Honor, we also filed pro hac papers from my colleague and partner Tim DeLang, and we respectfully request that he be permitted to argue on behalf of plaintiffs respondents today.
And that application is granted, and you too are welcome.
Thank you very much. Respondents would request
10
10 minutes.
minutes. Okay. 6, 2, 2, 3, and 10. Got it? Okay. Gail versus Abramowitz. Forgive me, the tongue doesn't seem to be working this morning.
And now, Your Honor, I guess I should, since I was asked, I am admitted pro hac piece for this. I don't know if I want to.
Okay. It's been granted. Go ahead.
I guess 10 is fine.
Okay. You want to split that up in terms of rebuttal? Okay. All right, I'm going to do 6 and 2 and 6, and we'll see how the argument goes, okay? People versus Eric Santiago. Okay. 5 and 2 and 3. Delgado versus Donald J. Trump for president. Okay. 4 and 2 and 4. Thank you. Graves versus Sava Serbian.
Your Honor, our public correspondent requests 5 and 2.
Okay. Okay.
Good afternoon, plaintiff respondent requests 5.
Okay, 5 and 2, 5, 5, and 5. People versus Charles Johnson. Submitted. People versus Dakeem Green. Okay. 5 and 2 and 5. Krifka versus Bronx Lebanon Special Center. Okay. Okay, which respondent is this? Plaintiff respondent, okay. Okay, Flatiron? Okay. 5 and 1, 3, 3 and 3. G Builders versus Eden Ballroom. Plaintiff? Okay, and defendant, next time, please make sure you put in your request in writing. You will get 2 minutes, okay? Yes, of course. You got it, 3 and 1 and 2. Ramon versus Frey. Okay.
Respondent request 4, Your Honor.
5 and 2 and 4. Chang versus 37 Plaza LLC.
Good afternoon, Your Honor. Appellant request 5 and 2.
Okay. Okay.
Good afternoon, Your Honor. Defendant respondent request 3.
Okay. All right, 5 and 2, 5, 3 and 3. People versus Jose Prado, submitted. Outlaw versus New York City Health and Hospitals Corporation. 5 and, okay. 5 and 2 and 4. And Schnur versus Balestri is submitted. First case on the calendar, People versus Lobriel. You may proceed.
Good afternoon, Your Honors. May it please the Court. Desiree Sheridan for Appellant Joe Labriel. Your Honors, the relevant inquiry for the reduction of a SOAR risk level is whether, after the initial classification, circumstances have changed so as to warrant a modification. And I submit that Mr. Labriel did meet this standard and that Judge Bruce should have granted his request for a modification to a level 1. I would point out, Mr. Labriel
Counsel,
has
Judge Bruce did in fact grant a modification, right?
to the level 2.
Okay.
Yes, but the level 1 was what was requested, and under the
But
circumstances.
is it what is appropriate, is the question, right?
Yes,
So tell us why this gentleman should have his level reduced after his reprehensible conduct against his own 9-year-old daughter.
well, I would submit to you that obviously the circumstances of the original offense are relevant. However, what the Board of Examiners of Sex Offenders has always said when they go forward on these modification issues is that you have to look at how circumstances have changed since the event. And since that event, it has been more than 25 years. And over those 25 years, Mr. Lobriel has remained offense-free in the community. He was released in 2001. He got off of probation in 2003, so he was unsupervised, and he has remained offense-free for those 23
Well,
years.
the question, counsel, is whether or not those factors outweigh the seriousness of his crime, right? That's the legal standard.
Yes, yes, and this is something I would ask the court to take note of. There's a Second Department case, People versus Davis, which I've cited in my brief, and the court in that case actually observed the fact that you can't get into a mindset where the nature of the underlying offense becomes the tipping point for whether a modification is warranted, and that seems to be
Well,
what's
I
happening.
didn't say a tipping point. I said whether the factors you mentioned outweighed the seriousness of the crime.
Yes, under these circumstances, I submit that they do, because not only do you have this gentleman who's been offense-free in the community for over 25 years, but he's also taken additional measures. For example, he's extremely involved in his church. He's a deacon in his church.
I'm glad you brought that up because, you know, there are several letters from the church members, but I found it really interesting that the letters don't even address the offense. So I'm wondering, were they even aware of the offense?
I mean, that's something that I can't speak to. I don't know that they did know or that they did not know, but
The weight of them would certainly be greater if they did know and wrote that letter anyway, right? So not knowing is a deficiency that,
But I think it would be speculative to say that they didn't know, because it's also entirely possible that they were trying to be discreet, that they didn't want to put something in the letter in
discreet
writing.
with the court who is considering whether this man who was convicted of raping his daughter,
That,
we know. So sending a letter to a court, you don't have to be discreet.
I know.
Actually, you should tell us everything, so that we could consider whether you are properly evaluating the person that you're submitting a letter of reference to, but you'll have time on rebuttal.
Okay.
Good afternoon, Your Honors. And may it please the court, Connor Glendinning for the people.
So, counsel, why shouldn't we reduce even further to a level 1, given that this individual has been at liberty for over 25 years, and he has not gotten into any further trouble, and this is his only offense?
While it is true, Your Honor, that he has been at liberty, he has been offense-free for over 20 years, that is something that the court below considered. The court conducted a balancing test. The court's order says that in the totality of the circumstances, he believed that a level 2 was appropriate. And so here we have...
But the board recommended a reduction to level 1.
Well, Your Honor, yes, the board said that it would not oppose a level 1, but I really think that that looks more like a no position than it does an endorsement of saying that defendant should be a level 1. And I think particularly in light of the fact that the board also highlights some more concerning features of the defendant's mitigation, including his purported relationship with his grandchildren, in addition to his lack of proof of completion of sex offender treatment. The board highlights some issues, and I think that the board doesn't really necessarily endorse level 1. And I think it's for those same reasons that the court below considered all of these factors and believed that in granting his motion in part, he reduced to a level 2. He considered that, and I've cited in my brief where the period of time in which he has been offense-free is not necessarily dispositive of whether or not...
What about all the other issues that he has offered? The fact that he's now involved in his church, that he's we can say a respected member of the church. He's a deacon. He works with different groups. Do we consider all of that?
Sure, yes, Your Honor. I mean, it is certainly possible to consider that, but I don't think that it meets the clear and convincing standard here that he's required to meet in order to show that those facts actually reduce his risk of reoffense. I mean, the allegations related to his involvement in his church don't address whether any of his faith-based counseling has ever addressed his crime here, his sex offense, or whether that even addressed his own claimed sobriety. So I think that the allegations that he makes, while the court can consider, do not meet the clear and convincing standard that he's required to meet in order to show that he does not pose now a level 2 moderate risk of reoffense here. As a result, the people submit that defendant did not meet that clear and convincing standard, that the court below conducted the balancing test, which is proper under the Court of Appeals, People v. Shader, and the court asks that you affirm. If there are no further questions, I'll rest my briefs. Thank you.
1 minute.
So just to briefly state, the Board of Examiners of Sex Offenders were aware of all of these elements, factors that you've gone over, and they still nevertheless said they would not oppose a level 1. And that recommendation is essentially tantamount to
Counsel,
an
has your
approval.
client taken responsibility for his actions which occurred over the course of 2 years raping his daughter?
Yes, Mr. Alabriel did take, he expressed remorse, he took responsibility at the hearing, at this oral hearing in front of Judge Bruce. He did do that, submit a letter, stating his remorse. But again, the board was aware of all of this, and
Am I correct, this is the case where he claims there was only 5 instances?
in
And the daughter says that's not true?
in the original case summary, that was in the case summary, but since then and at that time, and again, I would maybe chalk that up to confusion on his part, or
Confusion?
or maybe not understanding. But
Confusion? He had confusion about the number of times he raped his daughter?
since that time and at the hearing, he did take responsibility and express remorse. He also did receive treatment while incarcerated, and it was an element of his probation, which he successfully completed. And again, the board was aware of this, and they still suggested a level 1.
Thank you. Pettinato versus EQR River Tower. You may proceed.
afternoon.
Having trouble with the clock. Go ahead.
That's no problem. Good afternoon. May it please the court. Dara Rosenbaum for defendant appellant River Tower owner. This is certainly a traumatic injury, but this case turns on sequence. The dispositive fact is that the plaintiff lost consciousness before she had any contact with the shower track. The undisputed record
How
is
do you know that?
because she testified to that. She testified that she felt faint for up to a minute. She then lost consciousness. She doesn't remember what happened next. She wakes up in a pool of blood and her husband is doing CPR.
But did she also testify that she slipped?
She testified that she may have slipped. And her suggestion that she may have slipped is speculative and unsupported by the record. Her own testimony and her own...
She said she had 1 foot out of the tub, and then her foot slipped, and that's all she remembers.
She said her foot may have slipped. She knows she lost consciousness, her foot may have slipped. Her own testimony and her medical records are consistent that she felt faint, suffered a loss of consciousness before any contact with the shower track. Under these undisputed facts, there's no evidentiary basis to conclude that the track caused or contributed to her fall.
Well,
But does it have to contribute to her fall or to her injury?
It has to contribute to her fall, Your Honor. The proximate cause requires more than that the condition be the instrumentality of the injury after the collapse. The undisputed record is that the track didn't cause or contribute to the fall itself. She lost consciousness and then collapsed onto the track. The track itself did not cause or contribute to the to the accident or to the fall or to the collapse. It contributed to the injury. And I think that's an important distinction in terms of the chain of causation. This is
Are people, is the occurrence of somebody losing consciousness, feeling faint in a shower such an unusual event that one can say it's not foreseeable?
I would say that even if it is foreseeable that somebody could slip and fall in a bathroom, even if there is a dangerous condition, and even if there is a dangerous condition, even if there's notice of a defect, there still has to be causation. And the undisputed record here is that there's no causal link between the track which caused her injury and the causation of her fall, which was a medical event. It's not a slip and fall case. There's no evidence that the condition of the shower or the tub caused her to lose balance or misstep. Instead, she testified that she felt faint for up to a minute, attempted to exit the tub, and then lost consciousness. At that point, the accident was already underway. The shower track did not cause the fall. It was the surface that plaintiff contacted after she had an independent collapse. Proximate cause requires that the alleged condition cause or contribute to the happening of the accident, not merely to the severity of the injury after the independent event. Here, the medical event caused the collapse. The track did not create the risk of falling, and it did not cause or contribute to the fall itself.
what about the tub? According to the expert, there's a slippery condition there.
But plaintiff doesn't ascribe her fall to a slippery condition. The expert may say independently, I believe the tub is slippery.
Why are the facts of this case not amenable to the conclusion, the circumstantial conclusion that she slipped while trying to alight the tub and then fell on the instrumentality that cut her?
First of all, I believe it would be an incredible coincidence that she was having a syncopal event, feeling faint, and then she slipped.
What is so coincidental about that? I don't understand that statement.
That she was having a syncopal event, she was having a fainting spell, she was having a reaction to a medication that she was taking. She felt faint and dizzy. If she slipped, I would ascribe it to the feeling faint and dizzy, not to any condition of the tub.
Why is that statement not speculative itself?
Well,
and why shouldn't a jury be allowed to decide which one it is?
Because the only thing...
How can we decide that as a matter of law?
Because the only thing that plaintiff says is that she may have slipped, and that would be speculative, and that should not get...
Yes, but we can also take from the circumstances, you're wet, you have to lift your foot over the tub and the railing of the shower apparatus. Why is it so beyond the facts we have before us? We tell juries all the time that they can uh, reach conclusions based on circumstantial evidence. So why is that not the case here?
Because the circumstances here are that she lost consciousness and that she collapsed onto the shower rail, which
Can we take into consideration the injury itself?
the injury itself is gruesome. There's no question about that. I've said that this is a traumatic injury, but to me, and under the law, the injury doesn't drive causation.
Counsel, tell me, why isn't it the case that the failure to, remedy that sharp, shower slide, why wasn't that a substantial cause of the injuries? Because all throughout the record, we have the affidavit of the plaintiff saying how numerous times in the apartment, doing work on the shower, including that slide. We have the expert. So why is it that, people slip, in the shower, in the tubs all the time? So why is it that that failure is not a substantial cause?
I would say a couple of things. With respect to the inspections that are referred to were macro-level inspections in connection with a redevelopment effort.
I'm referring to the work.
The work. There was no work, Your Honor, on the shower door. There was an unclogging of the shower, I believe, or an unclogging of the toilet.
Which means that if you have to unclog the shower that has a door on it, they had to bend over the very railing she cut herself on. So it seems to me they would have seen it.
Because I'm looking at page 369 of the record, paragraph 15, and it details all the work that was done, and certainly fixing the shower door on occasions after it came off the track from the rail.
I would say that for 8 years, plaintiff used this shower daily without incident and without complaint. She never complained to anybody.
She never fell on it.
But she never complained. If it would have been obvious to somebody incidentally seeing the shower door in connection with a repair, it certainly should have been obvious to the plaintiff who was using that bathroom daily without incident, including using the shower door immediately before the accident happened.
Thank you.
Thank you, Your Honor.
Your Honor, I'm Patrick Brophy on behalf of the plaintiffs. Respectfully, I believe that the appellant's argument misses what is really the important law, and for these reasons, in our brief, we leaned into the cases of Pagan and Delaney, where in Delaney, you've got someone using a bathroom, a toilet in particular, for the purpose that it's made for, and Ms. Delaney is sitting there, and unfortunately, she faints. And Ms. Delaney falls into a thing that is right next to the toilet. It happens to be an unprotected steam riser and is burned. And this court held that there was, that kind of a fall was foreseeable and that there was nothing intervening or superseding about Ms. Delaney's fainting with respect to her being injured by an unprotected steam riser. Similarly, in the Pagan case, you've got a boy who fell in an apartment. This court held that it was not unforeseeable for children running around an apartment to fall, so it's important to not have things that can slice children in the apartment. The child fell into a radiator with a sharp edge and sliced him. Similarly, in the classic Derderian case on foreseeability and intervening causes, again, the fainting of the driver in that case was also not an intervening or superseding cause. The hazard was placed where the plaintiff Derderian would be vulnerable if traffic left the roadway. That's not entirely unforeseeable. There's nothing unforeseeable here. Laura Pedonata was doing what you expect in a shower. There's three things you normally do in a shower. You step into it, you shower into it, you shower in it, and you step out of it. There's nothing more normal that you could possibly do.
But the argument here is that she did not slip in the tub as she exited the tub.
It's testified to in her deposition testimony. That's at record appendix, page 176. And she summed it up in her affidavit. That's at appendix, page 368. Around paragraph 6, not around paragraph 6, this paragraph 6. I placed my right foot outside of the bathtub in which the shower was located, and then suddenly my left foot was caused to slip, and I fell upon the shower door track with my right leg outside the tub and my left leg still inside the tub. She's clear as could be.
So that settles that.
And at an absolute minimum, there's a question of fact. But I'd go even further. One, I think it's clear enough that she slipped and then she fell on the track. It's debatable whether she lost consciousness before or after. But I also don't think that it is dispositively 100% comparative negligence to say if you're feeling lightheaded, which all of us at some point in our lives have, you reach for a book on a low shelf and you stand back up again, a little lightheaded. Usually we don't lose consciousness. To think that, oh, I should sit myself down in the tub and hope that Dustin comes to find me. No, she made the call. I'm feeling lightheaded. I want to step out of the shower. I want to get to my bedroom and I want to get to my husband.
Is that choice to make her solely responsible for her accident?
Absolutely not. I wouldn't want to be in the shoes of the lawyer asking a jury to hold that against her.
Thank you.
Thank you, Your Honors.
Counsel, you have 4 minutes.
Good afternoon, Your Honors. May it please the court. My name is Brian Ferrara for respondent, defendant. Oh, I'm sorry. There we go. Can you hear me now?
Yes.
May it please the court. My name is Brian Ferrara for defendants, respondents, EQR, River Tower, LLC, and ABCDE. We take no position with respect to everything that's been argued so far. Just a brief portion of the appeal does deal with the cross claims, which the lower court denied the appellant's motion for dismissal of our cross claims against them. We are the prior owner of the building. The sales agreement was very clear. It had an as-is clause. We gave the purchaser of the building numerous chances, I believe it was over 100 times, to inspect the property prior to the incident. They signed an as-is clause. Also, the sales agreement contained a clause with respect to a release, saying that any claims.
Counsel, have you provided the sales agreement in the record?
Yes. Well, the issue of the sales agreement was that the appendix that was the record on appeal that a appellant provided, it was not part of that. Yes.
So it's not part of the record?
It is not part of the record, no. Yeah.
So how do we assess it if it's not part of the record? We have to take your word for it?
Well, it's in terms of the actual underlying motions, it was there. We did request that it be denied because the entire record was not on appeal, was not submitted. That was a portion of my argument as well. We asked, let me just see here. The appendix prepared by River Tower was insufficient to allow for the appellate review. Where any appendix is patently insufficient for the purposes of the appellate review, any appeal as to such issues must be dismissed. And in their actual appeal, they cite no case law or any sort of support that would warrant a overturn of the lower court's order denying the branch of their motion for summary judgment as to our claims.
Okay. Any questions?
Thank you, Your Honors.
Your colleague has time on rebuttal.
Very briefly, I'll start with EQR. Start with the EQR issue on indemnity. Counsel argued that there is an as-is clause, which obviously is an allocation of risk, argues that there's a release, does not argue there's an indemnity clause. There is no indemnity provision. There can be no contractual indemnity without an indemnity provision. With respect to what my colleague, Mr. Brophy, argued, I'm not arguing that there's any factor that makes plaintiffs solely responsible for the happening of her accident. What I am arguing is that there's no causation, no causal link between the shower rail and the happening of her accident, which was caused by an unfortunate medical event that she suffered. If there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
Alesco Preferred Funding versus ACP Re.
Thank you, Your Honor, and may it please the court. John Bash from Quinn Emanuel for the ACP Tower defendants. Now, given New York's status as the financial capital of the country and of the world, it's no exaggeration to say that the decisions this court makes on corporate separateness, veil piercing, and the rules governing complex mergers and acquisitions set the law for the country and in many cases the world. In this case, Supreme Court made several fundamental legal errors on the undisputed facts on doctrines like de facto merger, mere continuance, alter ego, and the boilerplate, meaning very common language of the contractual provisions at issue here, and it did it in a context that will be very damaging to insurance bailouts in the future. Remember, 8 different regulators approved this deal over a decade ago to save insurance companies from imminent collapse in 2014, and now hedge fund speculators are trying to unwind the terms of those deals a decade later. Now, with the court's leave, I know we have a lot of issues in this case and a detailed record. I'd like to march through what I consider to be the most significant legal errors of Supreme Court below, although there are many more stated in our briefs. Let me start with the contract issue. This is the issue of whether, as a result of these 4 transactions starting in 2007, the TRUPS, which is the securities at issue here, liability essentially got bumped up to parents of the issuers or acquirers of the issuers. Now, there are 2 problems with that argument. They're independent. They're sufficient for reversal. Let me start with the first one because it has nothing to do with the surviving entity issue that this court addressed in the first appeal. The first issue is that each of these transactions, for different reasons explained at pages 20 to 24 of our brief and 8 through 11 of our reply brief, don't satisfy the language, not counting the surviving entity language. I'll just give you one example. Don't have time to go into all of them unless the court's interested. The 2009 deal, the TRUPS issuers were not part of the deal. It was their parent. But the language in the contract says nothing about a merger or anything involving a parent. Now, I just want the court to appreciate the bait and switch that plaintiffs are offering today. We raised some of those arguments. Again, this is different than surviving entity. We raised some of those arguments in the previous appeal from a motion to dismiss denial.
Counsel, this argument is with respect to successor liability.
It is, Justice Michael, yes.
So you're saying that based on the contract provisions that there's no successor liability?
Correct, as a matter of law.
Now, what about the other side's argument that that issue has already been decided and it's law of the case that there was successor liability?
I was just going to get to that, Justice Michael, so let me try to answer your question, because there's 2 different answers depending on which of these 2 grounds we're talking about. On this ground, this is not surviving entity. This is these case-specific reasons they don't satisfy the language. In the first appeal, we raised some of those arguments. Their response, this is at page 23 of their brief in the first appeal, which is called Alesco. They said it's premature to address that argument now. It's wrapped up in factual considerations. This court's opinion did not address those arguments at all. We can only presume that the court agreed with the plaintiffs that it was premature to address those arguments at that appeal at that stage. Now we come here, Supreme Court told us it was law of the case. They're asking this court to rule it was law of the case. We have literally never had an adjudication of these arguments, which in my view are clear winners for us. I mean, just take that 2009 deal. It did not involve any of the issuers. It involved their parent. The language doesn't say anything about a parent. Take the
Does the language of that first order support your adversary's position that issue was firmly decided?
It does not, Justice Mans. I mean, I don't see a single...
Tell me why. What is it about the language of the first order that does not lend itself to law of the case analysis?
Even putting aside that it was a motion to dismiss, not a motion for summary judgment, this court addressed one thing that's relevant here. It held that you could be a surviving entity even if you haven't been entirely extinguished. That issue has nothing to do with the things I was just talking about. But even on surviving entity, we took that as the law of the case and as given. And what we did is provide copious evidence that they didn't just merely exist. Each of these companies continued as going enterprises with hundreds of millions of dollars in assets. I can't go into all of it, but I'll just point the court to the record, pages 4525 through 4636. And this is undisputed. By the way, their response to all this is not to contest those facts. It is to say, well, 5 years later, these companies collapsed. Well, it's undisputed that that was because of liabilities that arose later, not because of these totally routine transactions in the market. And if you want a record for that, please look at pages 4705 of the record and forward, and pages 4637 and forward. We have copious analysis that's undisputed that they collapsed because of later arising events, not because of each of these transactions. Now, if I could, I'd like to switch gears to common law successor liability. Again, as a matter of law, undisputed facts, each of the different ways in which you can be a common law successor are not met here. Let me take the first one, de facto merger. It's clear in cases like asbestos that the hallmark and the requirement for a de facto merger is that the owner of the predecessor company is also the owner of the successor. It's clear, TBA, asbestos. It is undisputed that that is not true at all here. There is 0% overlap. What happened in the 2014 deal is that ACP paid all of the shareholders of Tower cash in exchange for their shares. Like, there's zero overlap in ownership. I see my light's off. I don't want to go anything. Okay.
Going, I've
There's,
added a few more minutes to your time because we're not nearly through, and I will add equal time to your side.
Thank you, Your Honor. So this is undisputed. Asbestos holds there has to be overlap of ownership for de facto merger. It's undisputed there's zero overlap in the 2014 deal, which is the focus. I can answer more questions about that, but I know we're time limited. So let me go to mere continuation. That's another way for common law successor liability. The Court of Appeals has held in Schumacher that you actually have to be totally extinguished as the predecessor for that doctrine to apply. My friend relies on a case called TAP Holdings. All that said is at the motion to dismiss stage, you can basically say they're about to be extinguished.
Counsel, the arguments that you're making, are they not fact-laden, and wouldn't that lend itself to a jury trial?
Justice Michael, I don't think so, because at summary judgment, if a dispositive fact is undisputed, then that is appropriate for summary judgment. And in these two cases, the fact that there was zero overlap in ownership and the fact that these entities continue to exist and in fact thrive with hundreds of millions of dollars in assets for many years after the transactions, that cuts off these theories as a matter of law. And just to give you the big picture, lots of companies, as you know, rely on New York law. And the normal presumption is that a parent is not liable for the debts of the subsidiaries. These are narrow exceptions.
I'm glad that you said lots of companies rely on New York law. We should also rely on New York law for this case, right?
Well, in some issues, yes, and in some issues, no, unless you're including, Justice Michael, in that choice of law. Because New York choice of law is clear as day. I know we're getting into the alter ego issues. It's clear as day that the state of incorporation governs alter ego. Both of the two parties to the main 2014 deal were Bermuda corporations. Bermuda has a huge interest in this. They regulate.
But didn't Bermuda acquire these entities after the fact? And so I'm a little troubled by the idea that a contract entered into 1 year gets acquired by another company years down the line. Somehow that changes the jurisdiction and choice of law?
Oh no, Justice Manzanet. The point I'm making now.
Did I miss something?
Yeah, there's a zillion
Okay.
transactions. The point I'm making now is about the 2014 deal where ACP acquired Tower. The reason I'm focused on that for alter ego is the whole way they bring in all these Carfunkel entities that Mr. Zauderer is going to talk about is they say they dominated ACP, and so they're liable for whatever ACP took on in that deal. And what I'm submitting to the court is it's undisputed that Tower and ACP at the time of the deal were Bermuda incorporated companies.
But that's the only contact with Bermuda, right? That they were incorporated in Bermuda, right?
Oh, no, Justice Michael, there are a lot more contacts than that.
But the contacts are more, are regulatory, are filings that have to be filed in Bermuda, not pertaining to the underlying deal itself, right?
First of all, the deal said it had to be closed in Bermuda. But more importantly than that, Tower has a principal office, and this is all undisputed. As a principal office in Bermuda, it employs outside counsel in Bermuda, it employs staff in Bermuda. And this is not anything unusual. I mean, as you know, Bermuda is kind of like the insurance capital of the world. A lot of insurance companies have offices in Bermuda. The Bermuda Regulatory Authority had to approve this deal. So I think if you're applying
So
interest
there was
analysis,
something in your adversary's brief about the type of incorporation that occurred in Bermuda, which prohibited you from really doing business in Bermuda. It was just for filing purposes, that incorporation.
yes, Justice Michael, that's a new argument that they raised on appeal. It's waived, but I don't even care about the waiver because it's meritless. What the exempt company designation means under the Bermuda Companies Act of 1981 is that the business activities you conduct in Bermuda are outward-facing. And a lot of insurance companies use this. But you still can enter into contracts in Bermuda, employ staff in Bermuda, have offices in Bermuda, employ outside counsel in Bermuda, and as we see in this case, your deals are still subject to regulatory approval in Bermuda.
I just want to go back. What claims do you say are governed by Bermuda law, and what claims are governed by New York law?
3, Justice Kennedy. So 1, alter ego. I think that's very clear in cases like Sweeney and Kalb and Highland Crusader that we cite in the briefs. That's 1. 2, common law successor. We've cited cases like General Motor and Tommy Lee Holdings to say that common law successor liability is governed by the law of the state of incorporation. And I just want to emphasize for the court, because they're recent cases, the Court of Appeals in the last couple of years have decided Eccles and Ezra Sons. Those cases say the internal affairs of a corporation are governed by the law of the place of incorporation. In my view, common law successor liability, which is all about when are we going to essentially disregard the corporate form to impose contractual liabilities on a company that did not assume them, at least expressly, that falls comfortably within those doctrines. The third one, and I know Justice Acosta is going to talk about this more, is fiduciary duty. Again, this court has clear cases that say the state of incorporation governs fiduciary duty. And just to put a fine point on that, Bermuda alter ego law does not recognize the same standards as New York at all, and they haven't even made an argument under these foreign standards for alter ego, which are, I won't get into it, but it's called concealment and evasion. They haven't even made an argument. That's one. Two, Bermuda law does not recognize common law successor liability, period. If you agree with us on choice of law, we win that issue. Three, fiduciary duty. Bermuda law is clear that the creditors of a subsidiary, even if there's some duties owed, don't have standing to bring the claim. The liquidators have to bring that claim. Supreme Court's only response to that was, well, there's duties. It's like, whether that's true or not, and we dispute that, but whether that's true or not, that's a different question than who can enforce those duties, which I think it's undisputed in the record that it's the liquidators that can enforce them, not the people in plaintiffs' position. I know I'm way out of time. I don't want to cut off any questions.
One last question on Bermuda law applying. The cases that you cited, aren't they distinguishable from the facts that we have here, where we have your clients being headquartered here, operated here, the transaction consummated here, and New York attorneys used for the deal? Aren't those facts that we have here distinguishable from some of the cases that you cited?
Well, I don't know. It may be that the facts are different, but I don't think they matter because the cases we cite set out a flat rule that the law of the state of incorporation governs alter ego. That's both state and federal cases, Suina, Highland Crusader. At most, some of their cases suggest where there's literally no other context at all, and this is like dicta in Highland Crusader. If there's zero other context, maybe it's a different rule. But there's certainly not zero here where the Bermuda regulatory authority actually has to scrutinize and approve the deal we're talking about. I don't think that's a case of zero. And I just want to emphasize why under a normal interest analysis, even if you don't agree with any of these cases, even if I fabricated them, which I didn't, even if that's true, remember, it's all about what is the issue and which state has an interest.
With all of the things that I just mentioned, wouldn't New York have the interest based on all of those factors?
New York may have an interest in other substantive aspects of the case, like contract, tort liability, et cetera. But in terms of when is the corporate form going to be disregarded, I do think it's the state of incorporation that matters to. And you can just imagine if Texas started saying, we're not going to recognize New York corporations because we don't like their rules of incorporation. I do think, and the cases bear this out, that it's the state of incorporation that has the biggest interest in whether the corporate form will be respected.
Thank you so much.
Thank you, Your Honor.
Good afternoon, Your Honors. As my friend has indicated, I'll be dealing with two causes of action, Your Honor. The first is the fiduciary duty claim and the fraud claim. Our contention is that it was error for the motion court to deny summary judgment to the Tower Group directors and officers, on behalf of whom I'm arguing today, on plaintiff breach of fiduciary duty and fraud claims. First, there is no fiduciary duty to a subsidiary's creditor. Bermuda law is clear that, and plaintiffs acknowledge this in their brief, that like here, directors of a parent company owe no duty to troops holders, that is to junior subordinated creditors. There's no duty to creditors.
If that Bermuda law applies, then that obviously is the result. It has to be a dismissal on the Bermuda.
Our contention, Your Honor, is that that's correct, but even on the New York law, there's no duty to to creditors as here. Your Honor, what they're trying to do, and I just want to make this clear, these are sophisticated hedge fund investors specializing in distressed debt. They bought these troops at pennies on the dollar, knowing exactly what they were getting into. That's why they cannot credibly allege that there was intent to induce reliance on their part. They knew exactly what they were getting into. But with respect to the fiduciary duty, Your Honor, the fact that there's no duty that we owe is not just our opinion, it's plaintiff's own expert's opinion. Because plaintiffs knew this is why they have to contrive a narrow exception of bad faith and fraud. Their problem, Your Honor, is that the record shows exactly the opposite. A group of directors who, when faced with an insurance company in distress, did several things, but among them were canvassing the market for months for a viable transaction to save the company. They reviewed over 100 potential offers and made a sound business judgment that the ACP Tower transaction was the only viable option. They haven't come up with a single alternative to that. Everyone agreed that this was the only viable option, including the 7 state insurance regulators and the Bermuda Monetary Authority. Your Honor, the second issue I wanted to touch on, and I know my red light's on, but in 30 seconds, plaintiffs have no standing to challenge the ACP Tower transaction. Uncontradicted evidence as summary judgment requires creditors, like plaintiffs, to rely on company liquidators to pursue such claims. Plaintiffs' experts have offered no contrary opinion, and the lower court recognized that in their decision, record at 39, quoting their expert at record 7805 through 06. My third point is, Your Honor, is that the fraud claims also fails. Just putting duty and standing aside, the only support for plaintiffs' fraud claims are 2 allegations, Your Honor. They say they hold on to a fraction of a sentence in a 600-page proxy statement to shareholders that the board believed, Your Honor, believed the ACP transaction will provide the best opportunity for the assumption or repayment of Tower's indebtedness, including troops. This was a forward-looking statement, an expression of belief, not a promise, Your Honor. The other statement they rely on is an informal statement by Director Hisselberger to plaintiff's representative, Doug Duncan, that he felt good about capital levels and would expect that interest payments might resume.
Counsel,
At the time that that statement was made, was the company insolvent? So that statement, I'm satisfied with the capital levels, would be looked at as suspect?
No, Your Honor.
Okay.
So I mean, the point that I was making before, Your Honor, is that Duncan himself characterized the statements by Mr. Hisselberger as expectations, not promises. And finally, Your Honor, and I touched on the high standard for...
One question regarding insolvency. The lower court held or looked at the issue of if the company is insolvent, then the board of directors do have an obligation to make sure that any transaction is also in the best interest of the creditors. How do you handle that finding of the lower court?
Once the board of directors canvassed the market and came up with about 100 different potential offers and examined it, you have to give deference to that board of directors pursuant to the business judgment rule. They got to make a decision. Okay, what is the best option?
So you're saying you don't have to lay out a particular formula of how you looked at whether this deal was going to benefit creditors?
Yeah. Well, they do, Your Honor. And the conclusion, they hire experts to give them an opinion about the different transactions. And they did, Your Honor. That's why the ACP transaction was the best viable option. We were talking about $200 million precisely to pay reinsurance debt. And that's on the record of 5161. They also wanted money. The bottom line here is, Your Honor, just to cut to the chase, is that they want to jump the line. It's not that we don't know. That transaction basically raises the water and floats all the boats. Everybody's out here to make money out of that transaction, out of a company that's basically being revived. So the problem is that they are junior subordinated creditors, and they can't jump the line and get in front of shareholders and policyholders.
Thank you.
Thank you, Your Honor.
Everyone's going over, but that's okay. This one requires it.
May it please the court. Mark Zauderer. I just want to punctuate a couple of points on alter ego liability. The so-called Carfunkel defendants are not parties to these transactions. The sole theory that's left here, that's being advanced against them, is alter ego. They are 10 undifferentiated groups. 5 are not even addressed in the briefs. They could be my grandmother. Now, some of them have a corporate relationship, but what this court said in Cortland, and I argued twice in the New York Court of Appeals over a decade, this court's Cortland jurisprudence. Unfortunately, I was on the other side, and after 10 years lost it. But that's the point here. To show this kind of liability, there has to be, 1, complete domination and control over the entity that's otherwise sought to be liable, and 2, misuse of the domination and control for fraud or a wrongful purpose. There's no evidence at this stage on summary judgment as to any of that. There's just simply nothing there. There are allegations. It got up to this point. But that is a very, very heavy burden.
Right,
Of course,
the other side says that the defendants stripped the asset of all its value
Yeah.
so that it left the creditors with nothing to get paid. What do you say about that?
that there's no proof of that. It's just not here. That was in the complaint. Unless you have any questions, I'll pause and stop there. Thank you very much. Appreciate the courtesy.
All right. Okay, so I'm going to add 4 minutes to your time.
Thank you, Your Honor. May it please the court, Timothy DeLang on behalf of plaintiff respondents. I want to jump right into the choice of law issue on the alter ego and successor liability. Defendants just flat out misstate the law and they ignore the evidence. The law they rely on is from Highland. It's this department's decision, and it says presumptively it's place of incorporation. However, very key, unlike Serio, another case from the first department, this is not a case where the Bermuda entity's contacts with that jurisdiction were minimal, or where the Bermuda entities were, quote, controlled by an individual defendant from New York and all the transactions complained of occurred in New York, end quote. That's exactly what we have here. And I want to break it down because it's very important. We have alter ego claims with respect to ACP. Defendants try to lump their Bermuda contacts together. They want all of Tower's contacts in Bermuda to equally apply to ACP. It's simply not true. ACP is incorporated in Bermuda and it stops there. It is a wholly owned subsidiary of another ACP entity that is an LLC incorporated in Delaware, and that is owned 100% by Michael Carfunkel and his family trusts, which are all New York. ACP has 0 contacts to Bermuda other than the place of incorporation. Even more so.
So the case that you cited to carves out the factors that I asked your adversary a question about.
That's exactly right. And that's the first department's prior decision that said you look at the place of incorporation, but if the contacts there are minimal and the facts arising from the transactions at issue, you go beyond that and you look at what state has the greatest interest. Here it's unquestionably New York. And I probably should have started with this. We heard an introduction about how New York needs to protect insurance companies so that they can come in. New York is also the financial capital of the world. There are investors here, investors who rely on what is told to them, who rely on the terms of the contract.
Sophisticated investors, right? You're not going to rely with your eyes closed, right?
100%. I agree with that, yes.
And you have an obligation to do that, right?
Absolutely. And you have an obligation to do your own diligence. You have an obligation to look into it. You also have the ability to rely on public statements that are made and representations that are made.
Can we agree that as your adversary stated, this investment is by its very nature a risky investment? It's not one of the safe. It's not like putting your money in, bonds, right? Those are secured. You live long enough, you're going to get paid, right? So it's not that, correct?
I agree.
There's no question that within, securities, there are some that are safer and some that are not so safe. Some that, I've been here long enough that I look at these cases and I'm like, you invested in that, right? Like, it's like, wow, you're really taking a big risk. So on that spectrum, where do these fall on that spectrum?
I would say they fall in the middle. These are a bond type investment. It was created for tax benefits, but it is essentially a loan. You're providing a loan to, in this case, it was insurance companies, and that loan.
Is it really the middle though? Because it's one of those types of investments, from what I understand of the record, where potentially you could get nothing back if the company goes insolvent.
Correct. As a shareholder,
And the company is already struggling when you invest in it. Extensively struggling, right?
I do want to correct the record because defendants ignore this fact. Some of our plaintiffs did invest later in time. There's a large number of our plaintiffs who are CDO entities that invested in these securities at issuance. So it's not just the ones that defendants want to focus on. We have both. We have some of the plaintiffs who invested later. We have some plaintiffs who invested at issuance.
Some of them, they purchased 50 cents on the dollar.
Correct.
Yeah. Okay.
Right. But the key point here is you're investing in an insurance company and you are told and promised that the assets of that insurance company, the revenues generated there, are going to be there to pay back this loan, and that those assets are not going to be otherwise taken from you. That's what I'm going to get into the contractual language. But I want to finish on the choice of law because this is very important. You have ACP's auditors, BDO, and this is in the record at 9858. Right? And it goes through the history of who is ACP. It's a wholly owned subsidiary of a Delaware entity. And this is how they describe ACP's business. ACP offers solutions to property and casualty insurance companies located in the United States, not Bermuda. They don't do business in Bermuda. They never did. Later, describing ACP and who runs ACP, keep in mind, ACP has no employees. They don't even have an email domain. The individuals who are responsible, and this comes from defendants' own internal documents, are national general employees in New York. ACP is being dominated by New York entities. It has no connection to Bermuda. New York law applies. Now, with respect to Tower, we have a separate claim post-merger, right? After the merger, ACP took over Tower, and then the Carfunkel defendants, through their domination and control, essentially pushed those entities into shell companies, took the assets, and didn't pay back the Trupp's liabilities. That's our alter ego claim there. They focus on facts of Tower and their connections to Bermuda pre-merger. They don't talk about business that Tower did in Bermuda post-merger, which is the relevant time frame for purposes of this particular claim. And as their own CEO testified, Mr. Hitzelberger, they were shell companies. They had no business. They had no revenue. Clearly, they weren't doing business in Bermuda. Under the New York case law, under this department's own case law, it's not place of incorporation under these facts. You look further, and clearly New York has the greatest interest in this, and New York law should apply.
I want to go back to the fraud cause of action, because help me get there. Because you have this statement, in the proxy.
Yes.
That's for the shareholders to determine whether or not to vote on the transaction. Didn't go to your client, and why isn't it, like aspirational as opposed to a statement of material fact? Because one thing that the proxy statement did not say that there would be repayment because of the Tower ACP transaction. So get me there. How do we get there?
So I want to start with the fact that the proxy statement, they want it to be just to shareholders, but that is a publicly filed document with the SEC. It is available to the world to read and review. They have the expectation that people in the world will read and review
Right,
that.
but what about that statement, as was argued by your adversary? It seemed to me, as I read it, speaking only for myself, that it was a statement of projection, what they hoped would happen. That has never been something that is compensable, chargeable.
I disagree. It is if you don't genuinely hold that belief. And here, the statement is, we believe it will provide for the assumption or repayment of the trust. And I want to answer your question, Your Honor, first.
Sure.
If they didn't expect my clients to read that proxy statement, why are they making statements about the TRUPS within that document? If you're going to speak about TRUPS, you need to speak fully and you need to speak honestly, and that's the law. They chose to make representations about the TRUPS in that document. They can't now evade liability for a misstatement by saying, oh, we didn't
But
intend you
again,
to read
the
it.
statement is forward-looking.
Now-
What about that statement is a guarantee of performance?
We don't allege that it's a guarantee of performance. We allege that they stated they believed that it would provide for the assumption or repayment of the TRUPS. And they had no way to believe that because they did no analysis. And in fact,
What evidence in the record is there that they said something that we can point to and say factually it's clear that they had no reason to believe that?
that would be the Bank of America testimony from Mr. Gianmarco. I don't have the exact record site here, but he provided the fairness opinion, and defendants are relying on these fairness opinions that came out. He specifically said, we were not asked to review this transaction in the fairness to the company or the creditors, only to shareholders. There were then board minutes that had been altered. They had a draft board minute, and the final board minutes inserted that Bank of America had provided that opinion on behalf of the company. And he testified, absolutely not. We were never asked that. I don't know how that got into the minutes. So it's both there for Bank of America and the other fairness opinion.
Counsel.
Only issued on behalf of the shareholders.
Counsel, how do you address justifiable reliance? If you're a sophisticated investor and you see a shareholder statement, as my colleague said, that's forward-looking, don't you have to do your own due diligence? And why would you be relying upon them with regard to a statement that may happen in the future if you have to do your own due diligence?
Well, I think the question would be then, what due diligence needs to be done, right?
So justifiable reliance.
Correct.
Why are you relying upon that statement when it seems like more puffery than anything else?
I don't agree that it's puffery. I agree. I think it's a representation from the board that they have a genuine belief that the TRUPS are going to be assumed or repaid.
So what? They have a belief.
Correct.
A belief. That means it could happen, maybe it doesn't happen. I don't understand how you prove that that board didn't have that belief. How do you establish that?
And why wouldn't they have that belief? Everybody wants to make money, right?
Well, this is not money for the board, so they would have no interest in that. This is
Wait a
being
minute.
repaid.
Every board member has an absolute obligation, and you talking about fiduciary duty, you have a fiduciary duty to make sure that the company moves forward with whatever business decisions are being made in that boardroom. So whether you personally benefit because you're a stockholder or not is not the issue. As a director, that is your role.
I completely agree.
Okay, so, but what you said seems to fly in the face of that.
No, I was trying to respond directly to that question. I agree with what Your Honor just said, and I'm going to add to that, which is the problem defendants have, right? They tell the story, Tower was in trouble, Tower was failing, Tower was insolvent, it couldn't continue to go forward. So they have to enter into this transaction, and lo and behold, ACP and everyone comes in and bails them out. But then when you get to the breach of duty, they weren't insolvent. Because they know under Bermuda law, under Delaware law, under New York law, if the entity is in the zone of insolvency, then you owe a fiduciary duty to creditors. And they're trying to avoid that by sidestepping whether or not they were insolvent.
Let me ask you something. So let's say I agree with everything you just said. And now the board has to decide. This company is likely to go under. We've looked at 100 deals, and this is the best one out of the group. What's wrong with that? Why can't that board make that decision? Because the question is not whether they were right. The question is whether at the moment they made the best decision with what they had in front of them at the time. Isn't that what we're looking for?
No, they may have made the best decision for the shareholders. And certainly here, in an insolvent company, they allowed the shareholders to jump ahead of the creditors. That's not how it works in an insolvent company. $143 million were given to shareholders. That money should have been for creditors. They allowed that corporate structure of repayment to be skipped.
So, counsel, let me ask you this question. So, tell me, what evidence did your experts put in to indicate that it was that ACP Tower transaction that caused the breach, as opposed to the unseen increases in the claims liability, for those insurance policies from 2013 and earlier? Because I don't recall it, but it's a big record.
It's a big record, and our experts did not specifically provide that analysis.
Let me ask you another question. The fraud, we talked about the proxy statement. What about that 2015, I believe it was July 2015 phone call?
Correct.
Because the way I, explain it to me, because, once again, it's like, aspirational, what you want to happen.
It's a phone call between my client, Mr. Doug Duncan, and Mr. Hitzelberger, who is the former CEO of Tower.
Right.
And it's calling, asking about the trust preferred securities. And essentially, and we get this from the contemporaneous notes of Mr. Duncan,
Right.
who testified about the call, he remembered the call, and he took notes about the call. Important to keep in mind, Mr. Hitzelberger did not deny having the phone call, but he doesn't remember the substance, and he didn't take any notes.
Because we also have the sworn statement by Duncan that he asked if ACP was going to repay the principal amount, and he said he never even asked that question.
He did not ask that question. He was told that it was going to be on the balance sheet of ACP going forward, which he then interprets it's on the balance sheet. It's going to be their debt and their liability. And as part of his diligence, he's looking at, okay, is ACP and Carfunkel debt good debt to hold? Yes, I want to hold that debt. And I want to add one thing.
I'm going to give you one more minute because we are now in the 16-minute mark, okay?
I appreciate your patience, Your Honor. I want to point to the internal emails, and we cite to these, and they want to pretend that they're being honest with everyone. Internally, they're laughing about what they're telling.
That's after the transaction, right? That's after.
That's after the transaction, but it's also after he made assurances to Mr. Duncan that it was going to be on the balance sheet. So at a minimum, we're here, it's summary judgment. These are questions of fact. Let's go to a jury and let a jury decide them.
Thank you so much.
Thank you so much for your time.
Rebuttal.
Thank you, Justice Manzanella. I'd like to respond to some of the arguments, or some of the questions from the bench and statements, and I know Justice Michael's probably going to ask me about Highland Crusader, so I want to get to that in a second. Can I just pick up first with the fraud point? There have been pointed questions to my counsel about how this is just an aspirational statement. All of those are well taken, but it actually gets a little more ridiculous than that. The transaction document for this deal is attached to the proxy statement. It's 5053 of the record. So these are sophisticated parties. You're telling me they just assumed, based on this aspirational statement, that these liabilities would be assumed when they can just go look at the deal and see that they're not being assumed? This is not a mom and pop retail investor. These are sophisticated parties. So they have no justifiable reliance. Justice Hagler, you were exactly right about that. So let me get to Highland Crusader and choice of law. Respectfully to my counsel across the aisle, it is not true that ACP had no contacts in Bermuda. Not only were they incorporated there, Justice Michael, they were licensed, audited, employed outside counsel there, had a resident director there, and were regulated by the Bermuda Monetary Authority there. So this is quite different than what I had described as the dicta in Highland Crusader, where you essentially have no contacts other incorporation, but you may not agree with me on any of that. Let me try to convince you why I don't think it matters to this issue. First of all, as my colleague said, there is no wrong or fraud here. That is just rhetoric in a brief. They're talking about arm's length deals to save a company that would have gone under in 2014 on the undisputed evidence to pick up some of their customers when they renew and to reinsure their policy approved by independent directors.
Play out their scenario, and this transaction had not gone through. The underlying company would have gone under, and they still would be in the same position they're in today.
It's undisputed. I gave the court my opening presentation, all the record sites where we submitted copious economic analysis of that. They did not respond to that. This is not a battle of the experts. This is undisputed. It would have gone under. That issue, Justice Manzanet, cuts across most of their claims because it eliminates causation on the tort claims. It shows that none of these transactions are the reason they went under. It was later developments. To answer your question about the Hitzelberger call and was the company insolvent, my best understanding, although I think insolvency can be disputed because it's a little bit of a squishy standard sometimes, my best understanding is no, and here's the reason why it's no. 2014 is when the deal happens to save the companies. July 2015 is that call. Then the new liabilities get figured out towards the end of 2015 and 2016, which pushes them into conservatorship. So I actually think that call was in the sweet spot where they were not insolvent. But it doesn't matter because in terms of the fraud claims still in the case, they don't allege Duncan purchased any TRUPS after that call. This court does not recognize holder claims, meaning you already have the thing and then they lie to you about it and you don't sell it. That's Feinberg and all the cases leading up to that. They say, well, we have out-of-pocket damages. No, what this court's precedent says is a holder claim is not out-of-pocket damages. If I could make one more point just to make sure on the asset stripping, that is just one sentence. That is just rhetoric in a brief. These are arm's-length deals approved by 8 regulators to save a company.
But rhetoric that Judge Barak totally bought. So why?
All due respect to Justice Barak, but there is simply no evidence. We'd urge the court to look at the record. I'll give you one example of what's going on here with their string of citations to the record that don't actually support what they're saying. They say at one point that there's an internal presentation that said ACP gets no benefits of this deal. It's only AmTrust and NatGen, and they use that to say it's alter ego. That presentation starts at page 12679 of the record. There are literally parts of that presentation that say, here are the benefits to ACP in terms of fees and investment income. A lot of their citations are like that. They're relying on balance sheets, which have nothing to do with legal liability. You're required as a parent under GAAP to include subsidiaries' liabilities on your balance sheet. That has absolutely nothing to do with legal liability under New York law. We'd ask this court to reverse in full.
Thank you so much,
Thank you.
gentlemen. Thank you. I'll give a second for your entourage to leave. Okay. It's an extra copy. All right. Gale versus Abramowitz. Yes, of course.
May it please the court, I'm Ken Albert, and I'm here representing plaintiff appellant Pamela Gale. It's pretty clear that I can just jump right into the meat of this. It's
Yes.
first time here,
Oh, okay.
obviously, and so it's pretty clear. I can just jump right in. And by jumping right in, I mean explaining why this court's decision in Weiss does not compel dismissal of the legal malpractice action in this case, the way the lower court believed it did. And the reason Weiss is not controlling in this case lies in the fundamental difference between the facts in the underlying case in Weiss versus the facts in this underlying case, and the nature of the damages being sought in the legal malpractice case in Weiss, and the damages being sought in this legal malpractice case. Now, in Weiss, which it's not going to take too long to describe because it's only a paragraph
I would
anyway.
suggest that you focus on your case.
Well, okay, the reason, okay, but if
I
I'm talking,
strongly suggest that you argue your case.
okay.
Okay?
Your Honor, I'm here to suggest and argue that there are in fact actual ascertainable damages in my case as compared to the conclusion that this court reached in Weiss that there were none there. And the reason why, once again, though, is the nature of the difference in facts between the two cases, but I will relate to my facts. Here, plaintiff appellant hired defendant attorneys to represent her in a matrimonial action.
We're familiar
We
with
know
the
all
facts.
that,
We know
right.
what happened.
And
They forgot to include all of the taxes in the filing, and as a result, your client didn't get everything she was entitled to at the outset. She had to hire a new lawyer in order to get what was due her, and she has now filed this claim against them for that failure.
Seeking, yes, seeking
Okay.
only the attorney's fees and expert fees that she was required to pay in order to accomplish that.
And the expert and attorney fee she was awarded from the Supreme Court doesn't cover the full cost.
That's right, but that's right, Your Honor. But I'm here to suggest that even if it did, it wouldn't change my argument.
Okay.
Okay. I want to say that there's a difference. There's a difference between. All right, let me put it this way. When Ms. Gale hired defendants to get her what I'm going to round off as a $2 million judgment in the matrimonial case, and they failed to do that, she then was required to hire subsequent
Can
counsel.
I stop you because, can I make it simple? Because I think there was a $2 million judgment that you got ultimately, but you're saying an extra cost of $430,000 is remaining. Is that correct?
There were, that's right, the fees that they paid subsequent counsel. And this is what I want the court to wrap its head around, if you will. There is a fundamental difference between being in a situation where you have paid your attorneys and they've given you the work and you haven't gotten your judgment yet because it hasn't been paid yet. The financial situation that you're in that situation is fundamentally different from the situation you're in where you have to actually lay out an extra $400,000 to then get the judgment you want. You're sitting there in your pocket. There is $400,000 of actual cash less in your pocket than would have been, not earning interest, not working for you. That is the fundamental difference between this case and Weiss. And that's why there is, in fact, actual ascertainable damages in this case in the form of that $400,000 that she actually had to lay out. It does not matter even if it was all covered in the awards fee. The fact that she's light $400,000 is the actual
You're not
ascertainable.
suggesting that she's entitled to more than the fees and that she actually has to pay. You're not suggesting that she would be entitled to double dip.
No, of course
Okay,
not.
good. I'm glad that
No,
that's
of
not what
course
you're
not.
suggesting.
And of course not. But the question is that a factor that that should be worked into the analysis of whether there's actual or ascertainable damages? And the answer is no. It's certainly the case down the road, as between her and her ex-husband, that if she gets those damages back from these attorneys, she can now not get them from him as a result of the judgment that she has. But that's between them, and that's a contractual matter. That doesn't change the nature of the $400,000, give or take, that she is suffered right now, actual and ascertainable damages, and Weiss does not say anything to the contrary, because it only addresses actual legitimate fees that were paid and the judgment itself. That's it. Weiss does not control the court's decision with respect to the legal fees that were paid subsequent counsel.
Thank you. May it please the court, my name is Lisa Shrewsbury, and I am here on behalf of the respondents, Alton Abramowitz and Schwartz Sladkis. If I could just jump right into a couple of things that appellant's counsel said. And this is not in the record, but just to give some background.
No. If it's not in the record, then I don't want to hear about it. It's DeHore's the record.
Okay, but you made a statement that they forgot to add the K-1 statements to their submission, and that, I just want to say that's not true.
You didn't submit all of them.
No,
Is
but
that not accurate? That all, the court below found that,
no, that's accurate. Right, but
okay, so that's what I'm talking about. If
Okay.
I misstated it, that's what I'm referring to.
Okay, but for context, there was a discussion with referee Sachs to sort of streamline the submissions, and there was an agreement that they were going to enter everything through the experts. That didn't turn out to be the case. Breach of duty is not the issue here. I just want to make sure for context that we have the background. in terms of the oversimplification, that it wasn't a $2 million judgment they were looking for. There was all sorts of issues. The number on the K-1s was not in dispute. It was the interest
Counsel,
income
just
box.
so that counsel, just so that I'm clear that I understand what you're saying, what we're looking at here, the underlying facts are that there was an award given, and a part of what was not awarded was based on information that was not presented to the court that the expert who testified relied on, but it was not admitted into evidence,
That's correct.
right?
Yes.
And the lawyers didn't admit that into evidence, right?
That's correct, yes.
Okay.
Yeah, no, I'm not arguing about that. But there are other issues.
Can I jump right in and ask you the question directly? Because counsel indicated that he can do a lot of things, but isn't there an extra cost that is ascertainable, that they're alleging to be damages of $430,000? They had to hire this new attorney because of the X, Y, and Z we just talked about, which is irrelevant, at least for my purposes, because the record is already clear that there may have been a mistake. But even so, why isn't that ascertainable, the $430,000 they had to pay to another attorney in order to fix, allegedly, the problem?
That's what I was getting to. So it wasn't just the issue of the amount of the interest. That was like the tail of the dog. The issue was she entitled to any amount of interest under the language of the postnuptial agreement, which basically just simply said she was entitled to 10% of the net profit distributions from the career project after adjustments for income taxes. So they fought bitterly about the definition of distribution, whether she was entitled to any distribution at all, the proper characterization of prior money she got, what tax returns to use. Do they use original tax returns or amended tax returns? The burden of proof, the definition of interest.
Okay, counsel, just so that I'm clear, was there an issue that caused her to have to hire a new attorney to fix a problem that had occurred?
Well, my point is it was bigger than the amount of the interest. There was the hearing before Judge Sachs, and there was the...
So I wasn't really inquiring about the details of it. I just want to know whether there was an issue that her initial lawyers didn't present, that she then had to hire other attorneys to rectify the issue.
I think it's more complicated than that because there were at least 9 issues that I was elucidating.
Well, I'd like to move to another area, if I may.
Wait,
because
she hasn't even answered her question yet.
So no matter what happened, there was going to be that 44003 hearing, no matter what. Whether
So it's okay to make a mistake?
No, no.
And the costs that she incurred are meaningless, and you and your clients should not be required to compensate her for what she had to incur?
I'm saying that there's no way to pinpoint a specific amount of expense that is attributable to this one issue because the issues were so vast.
So what's your solution? We do nothing?
Well, no, I'm not saying that, but she has been awarded fees, and there is case law that says that if an attorney is awarded some amount of fee, that there's the necessary determination that no malpractice has occurred. So there is a collateral estoppel argument.
Except that when your fee was supposed to be $2 million and you got less than $2 million,
she got
that's a
everything.
problem.
She's got absolutely.
Yes, and she had to pay extra to do it, right?
She hasn't.
That is a loss.
She hasn't paid. She's only paid my client $300,000. She has an award of $450,000 with respect to fees specifically earmarked for my client. She has a judgment, an enforceable judgment for those fees.
I'll now ask my question. You talk about collateral estoppel, and so can you explain that? How is that even applicable when the attorneys were not even parties to that proceeding below, and the whole issue of legal malpractice wasn't even addressed or adjudicated? So how does it even apply?
Well, she had her subsequent attorney put in an application for the fees that she incurred. She didn't pay, but she incurred with respect to my client. And she went to the court and said that, you know, I've been forced to incur these fees. I'd like my husband to pay them. And the court looked at everything. The judge was very involved in the proceeding, understood exactly what Mr. Abramowitz did and awarded him $450,000 in fees. There's case law that says that if there is a prior adjudication of a fee in favor of a lawyer, that necessarily means that there's no legal malpractice.
Thank you.
Thank you.
You have 1 minute,
I guess just to,
2 minutes.
thank you, Your Honor. The first, just to address the collateral estoppel, and only briefly, because I think in our papers we address it sufficiently, but the suggestion that my client gave the imprimatur and the blessing to the reasonableness and the quality and the competence of the legal work that she got when it cost her $1 million, because that's the award that she got, is just absurd. But more importantly, it flies in the face of the real law, which says collateral estoppel only applies when you had a real opportunity to litigate the issue you're being asked to be stopped on, and that didn't happen here for all the reasons in my brief. And so all I would like to say now is, if the court were to conclude that actually my actual and ascertainable damages argument as to the 400 to subsequent counsel is unpersuasive, and that Weiss, in fact, controls the way the lower court said, that still does not require dismissal of the entire case, which is what happened. And again, it's clear, it's set forth in my papers, but the damages that we're seeking, number one, the law in New York, as I understand it, is clear that an attorney's not allowed to pocket money for negligent work. And part of the damages that we're seeking is the return of any money that we paid for the negligent work that created the need to have to hire the other lawyers to get the real judgment. And even if we applied to everything as a matter of policy, even if it amounted to a double recovery, that would still not permit the lawyers to avoid returning the money that she paid for negligent conduct, for negligent work. That's number one. So that little piece of the pie needs to come back, in our opinion. And then there is also the argument that, in our brief, that once again, even if we supplies, she's not been made whole, because as was noted early on by the court, it was only a partial award. It was a significant award, and it was much.
Thank you. We've covered these arguments. Thank you so much. Have a good night. Thank you. People versus Eric Santiago. There you go.
Good afternoon. May it please the court. Rena DiFrancesco for Mr. Eric Santiago. At the time that the officers searched the fire escape and the bag, any potential emergency circumstance was abated. And to the extent that there was an emergency justifying that initial entrance into Mr. Santiago's apartment, the officers absolutely went beyond the scope that the emergency exception could have awarded them. So just to start, that initial warrantless entry into his apartment was not justified by the emergency exception.
Counsel, are you arguing that there's a gunshot, someone's shot, and then they see the hole, they go down to the floor, is not a reasonable assumption that maybe something is wrong and they should have a good suspicion, maybe they should investigate under the emergency doctrine?
So the context is very important here in that that initial call came from the downstairs apartment. The officers responded, saw that the 911 caller wasn't shot in the foot.
What the officers see, the important observations are, they see a bullet hole through the ceiling. So automatically, what can they assume? That the shot came through the apartment above. So it is completely justified and natural for the police to go upstairs to the apartment above where the shot came through. Thank God no one was standing underneath that spot. They'd be dead. right? So they had more than enough justification to knock on that door and inquire, right?
So even if that is true, even if
That's
that's
yes,
the case,
right?
well, not to secede that, but beyond that, even if that were true, even if
And
as
then
Your
what
Honor's
happened
saying-
when the door opened? What is it that the officer says? That he smells gunpowder. And this is not, some might say, oh, how often do police officers actually smell gunpowder? Except this guy is a trainer at the shooting range, so he knows gunpowder, and he's a former Marine. So we've got the shot going through the ceiling, we've got an open door from the apartment above, and the smell of gunpowder, which would absolutely let this officer believe that the shot came from inside that apartment.
That's very fair, Your
Okay.
Honor. But to go beyond that, that justification would have been limited to that search for a potentially injured person who needed assistance. But the officers, their search was not limited to that. It is undisputed that the officers searched the apartment. So they, under this reasoning, they did what they did. They came into the apartment, they looked for the injured person, they searched every room, knew that there was nobody injured in the apartment, which is what the officer testifies to, and then continue their search, which they weren't justified in
He
doing.
says that they see some makeshift blind kind of pulled back. And as I read it, it made me think that the officer was thinking somebody might have gone through this window, which is why this film has been pulled back. Why is that not? Why can't the officer look through that window to see if there's somebody on the fire escape?
So at that point, they already knew that there was nobody on the fire escape, which I think is...
How did they know that?
Because the officer, so the timeline of events is that the officer who testified, we don't have the testimony of the officer who actually found these firearms on the fire escape, but the officer who testified said that he went into, so he was in the bedroom, he left the bedroom, was in the living room, was able to see out the living room window and see the fire escape and that scaffolding.
Isn't it true that the covering was torn down? Wouldn't that be a suspicion to see someone may have gone there?
So it was partially torn down, which, there's a lot of reasons why someone's home might have a...
You see gun smoke. The assailant allegedly says, "I'm just watching TV," and then you see a torn curtain. Isn't it reasonable to investigate?
Well, so again, the officers knew that there was nobody on that fire escape. They saw, so the officer who testified said...
They only knew that once they investigated. If they didn't investigate, they wouldn't have known that, correct?
Well, they knew that before they opened that locked gate to look out onto the fire escape. So they couldn't actually see onto the fire escape before.
And what did they see on the fire escape?
Well,
Didn't they see in plain sight the gun?
once they opened and looked out onto the fire escape, they found the guns, but the officer...
In plain sight, on the chair, I believe, right?
Yes, once they actually went to search the fire escape. But first, the officer was able to see in clear view this fire escape and knew that there was nobody injured on it, then went back into the bedroom, saw that the officer was trying to unlock this locked gate, and then left again, and that's when they found out that's when he had heard from this other officer that they had found these guns. So at
Your argument is that at the point that they understood there was no injured person in the apartment, if they wanted to do more searching, they should have called for that search warrant.
Yes, exactly. And that's very well supported by the case law. And I just want to point your court's attention to People v. Jenkins, which had very similar facts where...
You can tell me about them on rebuttal.
Thank you.
Okay.
Good afternoon, Your Honor. Joseph Tucker for the respondent. If I could just clarify with regard to the fire escape, because I think that the facts are clear about why the police went into this apartment, and I think the facts are very clear that there was exigent circumstances justifying them going into the apartment.
You're not suggesting that, because in my questioning, as I laid it out, clearly they had more than enough reason to investigate the apartment upstairs.
Absolutely, yes.
But even believing, as I think they were more than justified to believe, that the shot came from that apartment, they can't just go into the apartment if all they are looking for is the gun. Am I right?
Oh, correct. Yeah, that's the second standard within the emergency doctrine. What happened here was Officer Giolta, who's the one who testified at the hearing, he did look in the bedroom and he saw two windows, one with the curtains up, one with the curtains ripped down, and that was the window that went to the fire escape. He didn't look outside the fire escape. He went to another room. He went into the living room. There were other officers in the apartment making a search because of a shot that was fired into an apartment with two children down below. When he went into the living room, he looked out, he looked at the fire escape, and he looked at the scaffold. He didn't see anybody. When he came back in, Officer Hussein, who was also conducting a search, was at the window, and Officer Hussein opened the fire escape window. There's a gate. He was the one who did that. So when we say they knew at this time, Officer Giolta knew, but not Officer Hussein. There were several officers conducting the search. So it was reasonable, and the suppression court found this, that it was reasonable for them to make a sweep to include the fire escape, which I would argue under People v. Holman, they have no right of privacy too. So that the officers looked on the fire escape to see where a person who was shot could be hidden, and right there in plain view, as the Justice indicated, there was a bag with the butt of a gun sticking out. I mean, I think that all the circumstances here warranted and justified the entrance into the apartment and the search of the fire escape.
Isn't it true that the gun was on the chair and there was a second gun in the bag?
There was a gun both guns were in the bag on the fire escape, but the butt of one gun was obvious from the view from the window on the fire escape.
Two guns,
There were
correct?
two guns. It was a 22 caliber gun, it was a 40 caliber gun, and I might add that the defendant was found on surveillance video afterwards throwing a loaded 45 caliber gun into the garbage outside the apartment building. If there's no further questions, we'll rely on the brief and ask you to affirm.
Thank you.
Thank you.
You have 2 minutes. I'm going to give you his leftover 20 seconds.
Thank you. So I just want to again reiterate that the officers knew that there was no one injured in the apartment. That's what the officer testifies to. And they testify, and again, it's undisputed that they were looking for a firearm, which was not constitutionally justified under the emergency exception.
The fact that they knew that there was no one injured in the apartment, was that at the initial encounter with the defendant, or after they had been in the apartment and gone through it?
That was after they had already been in the apartment and searched every room of the apartment. They did their sweep. As Your Honor mentioned, they should have at that point gotten a search warrant. They were in complete control of the apartment, and that's why I want to shift Your Honor's attention to People v. Jenkins, which was, again, very similar facts where officers heard gunshots. They followed defendant into the apartment. They seized the defendant, and the bedroom was in the officer's control, and the Court of Appeals found in that case where the officers then searched they knew that there was no one injured in the apartment, they searched a box that they had found.
Yeah, but this gun was not found inside a box inside the apartment. It was outside in plain view on the fire escape, which is kind of like a little different.
Well, the court still found that searching or continuing that search was unreasonable because the urgency that had justified the warrantless search had abated, that the police were in complete control of the house, and that before continuing that search, the officers had to get a search warrant, which is...
My recollection, I thought it was in the dresser too. They had to actually physically open up the dresser to go into the box. Here, as my colleague just mentioned, they saw the gun in plain view, which is outside. Isn't that very different or distinguishable?
Well, in Jenkins, they had found the box on the floor of the bedroom after the defendants had already been seized. And so in that case, it's very similar, where they continued their search, even though that original emergency had abated. They were in complete control of the house. No one was able to access the apartment.
It's not similar because we're talking about something concealed in a box versus something on a fire escape outside for which there's no expectation of privacy in a fire escape. So it's not similar.
Well, it's similar in the fact that the emergency, that initial emergency, if there was one, had abated. And so, and again, and I know this is in our briefing, that the lower court didn't find about the privacy or any lack of privacy, instead held on the merits that the emergency exception applied. And so again, the officers did know that there wasn't anyone on the fire escape. When the officer who testified had returned back to the bedroom, he saw that the other officer was trying to get out onto the fire escape. This wasn't some independent search. He saw that they were trying to search an area that didn't have that they knew didn't have an injured person, testified that they were looking for a gun, which was also shown by the fact that they were searching areas that could not hold a reasonable, that could not reasonably hold an injured person, such as Mr. Santiago's jacket and his backpack. He left the room, and that's when they went outside and found the gun. So,
Thank you.
okay, thank you very much.
Thank you so much. Delgado versus Donald Trump for president.
Should I wait?
May proceed.
Oh, okay.
No, you can go.
Your Honors, if it pleases the court, Adam Katz on behalf of appellant Jason Miller. The trial court dismissed 4 out of 7 of the causes of action against Mr. Miller, leaving a claim for intentional infliction of emotional distress, assault and battery, and violation of the New York's Gender-Motivated Violence Act. I'd like to take them in that order. The intentional infliction of emotional distress charge we believe was wrongfully kept in the lawsuit. We've cited case law, and we recognize that there's case law going both ways, but we cite case law that explicitly holds that the ASA does not revive a claim for intentional infliction of emotional distress. But more importantly, if there was ever a cause of action that would be subject to the CPLR 202 borrowing statute, it would be this one. The allegations in the complaint clearly allege a continuous cause of action, a continuous tort.
So counsel, can you explain to me, generally we have the continuous harm doctrine that extends the statute of limitations. How does the borrowing statute on the CPLR 202 bar it? Isn't that counterintuitive? Isn't that distinctly different?
Well, it says here that, so here it's beyond dispute that Mr. Miller and Ms. Delgado were not residents of New York, and it says that you have to take the shorter of the statute of limitations. So here there is no extension. There's a 1-year statute of limitations for an IED claim, and now the question becomes, would the ASA come in and allow her to extend? Our view
Based on a new rape? Why not? She alleges a second rape in New York, right?
Well, for
Yes? Is that a yes? to
yes,
my
yes, she
question?
does. She does allege that,
Okay,
Your Honor.
So why wouldn't the IED claim attach to that act?
Because it's continuous in nature.
It's not, a rape is not a continuous act unless you're there the whole time.
But
Okay, these are separated by time, so they're 2 separate and distinct acts.
Your Honor, the courts have held that with regard to negligence and intentional infliction of emotional distress, this is the Kidder case on all fours, where they are talking about intentional infliction of emotional distress. You can't parse out, you can't possibly say that she was not inflicted with emotional distress in Nevada or in Florida, where she's alleging. You can't say that didn't affect her and she was raped there.
Of course, that's not what I'm saying, of course. What I'm saying is that the second rape is a new injury. And comes with its own emotional baggage.
But the courts say that you can't parse out. The court in Kidder said that you can't parse out something that's continuous in nature. It involved a very similar act.
Kidder is a federal case, correct?
Kidder is a federal case.
It's not an appellate case that we have to follow. Is that correct?
Correct, but it was cited favorably by the trial court, and so our argument
And
is
the
that
trial court, do we have to follow the trial court's decision, or
No, you
can
do not- you do not
we
have to
review it anew?
I'm sorry, what?
Can we review it anew?
Yes, you can review it de novo.
Is there any appellate case law that would support your arguments? I haven't found any.
I would argue that the Aronitz case, if I'm pronouncing it correctly, does support the argument that that case involved a sexual harassment claim, and there were acts of.
That's a discrimination claim. That's not a tort, is it?
Well,
was there a tort alleged in Aronitz?
Yes.
Where was the tort? I didn't see it. I only saw discrimination. Is discrimination a tort? I thought it's a claim under the New York City human rights law or the federal law.
Well, discrimination and IED I would say that they're similar tort, because the actual sexual act.
Harassment and rape are not the same act. Those are 2 completely different acts. right?
Right, but
And a sexual harassment clearly is something that could continue. It could start in one place and the continuing harassment. But a rape is one distinct act. And then if there's another rape, that's a distinct act.
But the sexual act in Aranitz occurred in New York, and the court said, no, we're going to look
That was an act of discrimination. It wasn't an act of a battery or rape. The distinction is that it can't continue from the period of time when it first accrued to the last period of time. And they found in Aranitz that since it was one continuous act, therefore it was outside the statute. But as my colleague just mentioned, here we have November 10, 2016, there was an alleged rape, and December 6, 2016, all within the statute of limitations in New York,
Well, our view is that in my time is running out.
Putting aside the ASA issue.
Right. Our view was that was not pleaded in the original complaint. If you look at the original complaint, she provides many details about what occurred in Florida and Nevada.
That was the amended complaint. Why can't we review the amended complaint?
The operative complaint is the amended complaint, right?
If you find that it relates back, and our view is that it shouldn't relate back.
Let's assume it relates back. What's your answer?
Then, if it related back, then you would have to consider her New York allegations.
And what would that mean? Would that mean that the IED would be successful, or would have to be dismissed?
I would argue that it still would be unsuccessful because, again, you don't have to consider Kidder, but logically speaking, you can't parse out and say that she wasn't damaged there if she's saying that she was raped in Nevada and Florida and assaulted in Nevada and Florida, and that now anew that the intentional infliction just turned on in New York, and CPLR 202, which the court has held is supreme to the ASA, would.
It's not a question of whether the IED was turned on in New York, as you say, but it's where she can assert it, and the issue is, can she do so legally? You'll have time on rebuttal.
Okay, thank you, Your Honor.
Hey, please the court, Jeremy Hellman of Ryan Jeffa for respondent Arlene Delgado. Although counsel didn't really talk about it or at all, but I just want to make sure that it's clear to this court that regardless of the amended complaint, the original complaint, at the time the amended complaint was filed, the Gender Motivated Violence Act was still within statute of limitations of 7 years and 228 days, courtesy of the toll. So I just want to say that no matter what happens here, we still have a good Gender Motivated Violence Act case, and that is can't really be disputed because that is timely as of the date of the amended complaint of March 22nd, 2024. The statute of limitations would have been June 25th, 2024, 3 months later. So that is 100% timely and good. In terms of the amended complaint and the original complaint, Judge Frank did a great job of really setting forth why it was that the amended complaint does relate back to the original complaint and why the original complaint was adequate. He clearly talks about how there was a lot of allegations there. Now, I know my complaint was gigantic and had tons of stuff in different states and everything, but in a pre-answer motion to dismiss, you got to take
Counsel,
the whole
can
four
we get
corners.
into the specifics, because we all know the facts. How do you deal with Aranitz? Counsel says that Aranitz is on all fours, and that the 202 would be a bar.
So I just checked Aaronet's lower court decision, which isn't here, but it's on e-courts. And it says the case is for quid pro quo. It is not for sexual assault. And that's a big difference because quid pro quo is, well, that's an ongoing thing. It starts now and then it continues, and that's quid pro quo. When you talk about sexual assault, there's case law that says actually every sexual assault is separate. So that's not something you can
In
say,
terms of the IED, how does that work?
IED would be the same idea. It's based on sexual assault. That's what the basis.
So it leads back to the underlying tort, the IED. So since Aranitz led back to a discrimination case, and that is that goes from one to the other, and therefore was dismissed, this leads back to sexual assault, and therefore is actionable?
Yes, in fact, you can't really say that there's such a continuous nature that you could say, oh, it's all one giant IED. You can't even say that when you're talking about two sexual assaults, because there's only one allegation in the complaint that he's looking at to say, oh, this is just one giant big thing that's all together. Yes, there's one statement in the very, very beginning of the complaint that says it was an ongoing issue. Yes, it's an ongoing issue. How are you going to define this ongoing issue? You're going to say, oh, this is ongoing. Every single thing that happened here is the exact same. It's all one big giant tort. That's a reach. And you can't say that when all the evidence
Do you
has to be
have
looked at
case law,
in
let me
my light.
stop you. Do you have case law to support that the IED looks back to the underlying tort for accrual purposes?
Okay, well, IED, I mean, in of itself is its own tort. It's just based on actions.
No, so your distinction between Aronitz and your case is that you have to look back to the underlying tort. What case do you have that supports the proposition that you have to look back to see whether or not it's a discrimination case or some other tort?
Okay, well, even Aronitz was based on quid pro quo, and here we're talking about IED. So
That's distinguishing it. I understand that, but that gets you so far.
Right.
So to go a step further, how do you revive the IED? I understand you have separate causes of action, and we'll deal with the gender violence. That may be part of it, but I'm talking about simply the IED. How does that survive, looking back to the sexual assault?
Okay, well, he would still have to show that all the IED underlying actions were all connected, and we don't have that. We don't have a record of that now. I mean, this is a pre-answer motion to dismiss. Everything's in best light that's for me. And this complaint doesn't say, oh, every single thing that happened to her, it's all just one giant tort, it's all one giant IED. We don't have that. So without having such a record, he can't just create it. So for those reasons, and we have other issues on this appeal, but none
Are
of
you
them-
saying it's his burden to show it?
Absolutely, absolutely. I mean, you have to show why it is that they're all connected, and you'd have to have allegations that are in the complaint that show they're all connected in such a way that it's just one giant tort. Yes, we have one statement that there was an ongoing issue. Sure, there's an ongoing issue. How do you define when we say ongoing? Oh, no, that means the whole thing is gone. It's not fair to say that. And what we have here is torts that took place in New York, sexual assaults, and those were timely under the IED. So for that, I thank you, Court.
Thank you. You have rebuttal time.
Thank you, Your Honors. I believe it was more than just alleging that it was ongoing. I think paragraph 3 of the amended complaint also calls it a cycle. And in general, the complaint is pled as an ongoing, continuous series of actions. Again, it's not binding, but if you look at the facts in Kidder where the appellant was alleging a series of acts that occurred, I believe, in Pennsylvania and New York on a series of camping trips, the court basically says you can't parse out the different occurrences
Counsel,
that.
in the amended complaint, they specifically parse out the two assaults occurring in November and December of 2016. They did it themselves. In Kidder, that was not done. Isn't there an allegation in the amended complaint, two specific dates? And I know it was not in the original complaint of November 10th and December 6th. Isn't that pleading that it's not continued? They did two separate acts, two separate paragraphs, and two separate incidents.
Yes, but Kidder refers to specific. I believe it referred to a specific camping trip that occurred in the Alleghenies.
You keep on making the same argument, and you've heard us say that sexual harassment talk, right?
But Kidder
is not a sexual assault.
I know, but Kidder involved IED, and that's what I'm talking about. It's the two claims are the same. Aronitz, you're right.
What brings about the IED in Kidder is sexual harassment, correct?
No, that's Erie. Sexual, that's Aronitz. In Kidder, it's a person being assaulted on a camping trip by his uncle.
Got it. All right.
Yeah, right.
Mix the two cases up. Sorry.
Yes, sorry. And then with regard to my adversary's comment about the VGMA, if there's no relation back that's applicable, our view is that there's no New York, or there aren't sufficient New York allegations. The original complaint has significant allegations about Nevada and what occurred in Florida allegedly, but. Just to finish that thought, but there are no allegations. The allegation is that that they had dinner at Route 57 and that they drank together and that they were in a relationship in New York. Our argument is that that's not sufficient.
You're going on the first complaint.
I'm going on the first complaint and then the relation back.
We're gonna ignore the amended complaint.
Well, if there's a relation back issue, that's why.
Thank you.
Thank you, Your Honor.
People versus Dakeem Green. Oh, sorry, Graves. Graves, sorry. My apologies. The eyes are not what they used to be, gentlemen.
A little later in the day, Your Honor.
You may proceed.
Thank you. May it please the court, this is not a case of a failed safety device, and this is not a case of a missing safety device. This is a case where a person charged with the site safety deliberately removed the guardrails that protected workers from an opening.
Do we have evidence in the record that he deliberately removed the guardrails? We have testimony regarding that?
We do, and if you read the oath hearing of Mr. Donahue, he talks about how there were guardrails there and the workers weren't even supposed to be working there. And those guardrails didn't have a gate or a door. The only way to remove those guardrails was with a nail gun to remove the screws. And Mr. Donahue went on further to say that if work had to be done there, the plaintiff was the individual in charge with making that hole safe. And he cited 2x4s, plywood, safety lines, other items that were available.
Outside of the guardrails, were there any tie-offs in that area?
In that area, there weren't, because there was no one who was supposed to work there. And if they were going to work there, it was the plaintiff's responsibility to have the tie-offs and use the lanyards.
Wouldn't a place to tie off be a permanent location that, my understanding of how tie-offs work is that's a permanent spot where you can tie off your harness.
That's correct.
So that the hookup is what you need. And there's no evidence here that there was any such hookup for the capacity of a harness. There was none.
There was none because there was no work that was supposed to occur at that location.
But there was work occurring at that location, obviously.
Yes.
And, you know, we know on construction sites, they're not exactly always following their schedule. And the schedule gets backed up, it gets pushed forward, deliveries don't come on time, so you switch what you do today. That happens, right?
It happens all
the time. So the fact that, you know, do we know what was happening on that day? Why the guardrails, according to you, were removed?
Yes,
was it because of the work that had to be done there?
It didn't have to be done, but
there was work being done.
More
So
importantly,
the question is, did the guardrails have to come off for that work to be done?
Yes.
I know you're relying on Mr. Donahue's oath hearing, but he also noted that although there were safety devices available at the premises when he initially worked on the project, he wasn't even on the premises on the date of the accident, and he couldn't even recall when he was last there. So I'm not sure how we get to this, that it was, you know, deliberately removed. When he wasn't there the day of the accident, he doesn't even remember when he was last there.
Your Honor, record page 832, he says it was there. But more importantly, and this also answers Judge Manzanette's question, the plaintiff was the site safety person. He was the one.
That doesn't, the fact that he's the site safety person, are we now saying that site safety people don't have to be safeguarded under 240?
No, but if
okay, I'm glad that was your answer. So, does the fact that there is a site safety person change the obligation of the owner and the GC to make sure that all the workers are safe, including the site safety worker?
No, it doesn't change the obligation, but it changes who is protected under the labor law, because if he wasn't in charge of site safety...
Tell me where in the labor law it says if you're in charge of site safety, 240 doesn't apply to you.
The Gamez case, this court...
No, you said the statute. Where in the statute does it provide some kind of exception for a site supervisor of safety?
The statute doesn't protect anyone whose accident was the sole proximate cause of their conduct. And the plaintiff was solely responsible. He was the person in charge of site safety.
Who's responsible for making sure that a site is safe for the workers? It's the GC, right?
Yes.
The owner, right? And a site safety person, perhaps?
Yes.
Okay. Does the violation of any one of them change the duty of the other two?
No, but this isn't a question of
Exactly.
duty, Your Honor.
Exactly.
We're not arguing that
So
there's
you
no
have to
duty.
be able to establish then that he is the sole proximate cause of this accident for you to get out.
And we did.
How?
How? We offered the testimony that he was solely responsible for the site safety. We offered the testimony that these other items were there. Now, mind you, this is a...
What items?
There were 2x4s, there were 2x6s, there was plywood.
2x4 and a 2x6 ain't gonna stop somebody from falling in an 11-foot hole.
It will if you build a floor over the hole, which he was responsible to do and he had done.
You'll have time on rebuttal.
I didn't give... Okay.
You'll have time on rebuttal.
Thank you, Your Honor. Alexander Fisher from Milburn, Macris, Placidus, and Sidon for the third-party defendant, GPJ O'Donohue. Your Honors, I think that the salient point here is Mr. Graves is not only the site safety person, he's the person in charge of the entire site.
Again, what case says that if you're in charge of the site, the GC and the owner are freed from their obligation to keep workers safe?
There is no such case, Your
Okay.
Honor. But what
So the fact that he's the site safety supervisor doesn't win the day. What else is there?
it does not win the day.
Okay.
I agree with you, Your Honor. What I am saying, though, is it is a factor that must be considered.
Of course.
Because as the site safety person, the GC is not a monolithic entity. It's a person. He is the person at the site who's in charge of ensuring worker safety.
But the question is whether he was the sole proximate cause of his own accident. And we don't have anything in the record to establish that he was the sole proximate cause of his accident.
I would disagree, Your Honor, in this respectfully in this way. He was the person who could have built the barricade there.
Well, but that's the thing, right? When we start using words like could have, should have, would have, without any direct testimony from individuals who were present at the site on the day of the accident, all of that's speculative, is it not?
I would say it's not speculative, Your Honor, because his job duties were described by Mr. O'Donohue, the president of GPJ.
But as my colleague said, was Mr. O'Donohue there on the day of the accident?
No, I'm saying his overall job.
Overall, what he's to do is very different from having actual evidence that on that day, he was the sole proximate cause of his own accident.
Your Honor, what I think that the issue is not whether on that day. The issue is, does he have the
Let him finish his answer.
Does he have the authority to build a barricade, to get safety equipment, to stop the work if that's not there?
Equipment? Your adversary keeps saying he should have built a platform. I asked him, did the barricades have to be removed for the work that had to be done?
There's a barricade that's further out, and that barricade was removed to allow them access to this area. Now, that barricade was preventing anybody from getting into that area and should not have been breached. But once it is breached, he could have had a second barricade built over the opening in the flooring to prevent falls, or he could have said, we have to use harnesses. In fact, Mr. Graves...
But he couldn't have used harness because there was no place to tie off.
Your Honor, but he
So that was not an available safety device. It wasn't, because you need somewhere to tie off to use a harness. And there was none. The record is real clear. Even your side says that.
See, I would, Your Honor, I would respectfully disagree. He can arrange for that to happen, whereas a normal worker has the issue because he...
What evidence in the record is there from any expert that there was a place that he could have tied off from? There is none.
There is none. That's
Okay,
correct.
so that argument falls flat. But I have heard you. Thank you. We've got your record. Next up.
Thank you, Your Honor.
May it please the court, Chris Donadio from the law firm of Gare Conason. We believe that the decision of the trial court should be affirmed for two reasons.
Counsel, what I hear your adversary saying is that because your client was in charge of safety, that the onus was on your client to ensure that the area was safe. Is that how the labor law jurisprudence in this department works?
It is not. It is not. It sounds like a good argument, but it's not what the law says. The law was made very clear by the Court of Appeals in Cahill that in order to prove a sole proximate cause, there are 4 elements that must be proven. 1, there must be evidence that there was an available safety device for the plaintiff at the time of the incident.
And we don't have that.
No evidence. Strike 1. Strike 2, we have to have evidence that the worker was given an order to use that safety device or should have known that they had to use that safety device. We don't have that evidence.
Well, the should have known part, and I'll let you get back to the other two. I want you to. The should have known, does that rest in the fact that he was the safety superintendent? And be in that position puts him in a place where he should have known what safety devices to use?
If there were safety devices there, but there are no evidence that any were there. And the third, that he had a safety device that he was told to use, knew he had to use it, but chose not to use it. We have no evidence here that he failed to use any safety device.
Now, again, going back to the fact that he's the superintendent, wouldn't the direction of what safety device to be used, wouldn't that have had to have come from him, given that he was the superintendent and also the safety manager?
No, it wouldn't necessarily, Your Honor, because he is a superintendent. However, he has a supervisor, Brendan O'Donohue, and there above him was Gerard O'Donohue, the general contractors who were the bosses. It is their job to decide what needs to be done. In addition to that,
Did the GCs have the right and the authority to stop any work that they deemed unsafe?
yes, absolutely, Your Honor. They could have done that at any time. And I do want to make it very clear that in terms of whether work was supposed to be happening in this location, we have in the record, it's page 345 in the record, is the daily field report from that very day of the incident documenting where the workers would be working. This is the third-party defendant general contractor's records, and it indicates that a worker by the name of Jay was to be doing core drilling in the apps area. The core drilling is where the incident occurred. That was identified at the depositions of the third-party defendants, the general contractors. Photographs identified the area where this occurred was in the apps area. Again, this is that area they claim is the controlled access zone. Third-party defendant had it in their own paperwork that work was to be going on in that location that day. They did not provide any safety devices whatsoever to the plaintiff or to any other worker there.
And the work that was being done at the time was the drilling of holes for the erection of scaffolds that would get permanently placed in there during this renovation of this huge cathedral.
That is correct, Your Honor. And the drill is a massive drill, a very large drill bit. And that's why when that jammed and came loose, it knocked the plaintiff and knocked him down through this hole.
Yes.
So you mentioned 2 O'Donohues.
Yes.
And you said that one of them was his immediate supervisor?
One of them, yes. There was the boss or principal of the company, yes.
One was the owner, one was a supervisor?
Yes, it was a father and son.
Okay. So this supervisor, that person was regularly there at the job site?
Not all the time. And in fact, they were not there that particular day. They had been there prior, and they were able to confirm at the deposition that the area where they were working, that there were no guardrails. That's why there's no dispute about that.
Did they have the authority to tell or to, if they saw any unsafe work taking place, to stop the work?
Yes, absolutely they did, as the general contractor.
Thank you.
If there's nothing further, thank you very much.
I have 2 really brief points, one of which I didn't get an opportunity to speak of. The court denied my motion for common law indemnification as against the GC on the grounds that it was academic. That is not an academic claim. There are 2 insurance policies that cover this accident. One is a general liability policy, and the other is an employee liability policy, or a 1B policy. One has unlimited coverage, one is limited at $1 million. So the court granting summary judgment on a $1 million pot is not the same as granting summary judgment on both where there's more available funds. So clearly that's not academic. And I just want to correct one other thing. Labor Law 240 they don't require any specific devices. They don't require a guardrail or a lanyard or anything like that. They require whatever device is necessary to protect workers against the accident. So the lack of safety line does not entitle the plaintiff to summary judgment. If there are other ways of protecting this site such as building a platform over the hole, it's equally as good as having a safety line. Thank you all.
Thank you. Now people be green. You may proceed.
Good afternoon from Mr. Dakeem Green, Office of Appellate Defender by Christiana Prater-Lee. The evidence here supports what Mr. Green maintained all along. He committed a simple assault, but he did not commit robbery. In fact, the prosecution's initial theory that Mr. Green took the shoes, clothes, glasses, wallet, and money was completely undermined by the trial evidence. And its last-ditch effort in summation to claim that this third woman who appeared after the assault ended took the wallet and a single dollar fares no better. Even if her actions constitute a taking, which they do not, there's no evidence that she shared an intent with Mr. Green, nor that Mr. Green solicited, requested, commanded, importuned, or intentionally aided her as required to make out accessorial liability. As to the shared intent, Mr. Green did not have an intent to steal here. As he testified, he was acting out of revenge, and a use of force alone cannot make out an intent to steal. His testimony shows, and it's supported by...
When we see, because we saw the video, when we see in the video that Mr. Green punches the complainant and the complainant falls, and then Mr. Green stomps on the complainant, Mr. Green says in the chest, prosecution says in the head, but in any event, the complainant is out cold. Mr. Green, we see him sort of like go through part of the complainant's clothing, either the jacket or maybe his pockets. And then he gets up, and then this lady comes. And then they all gather around this complainant, and they look, and then they retrieve the wallet. And you see them all walk back, going through the wallet, and then throwing it away. So why can't we say that his intent was not to take property from this complainant?
Yes, Your Honor. I'd focus on that moment that you started with when Mr. Green is next to Mr. Matos, and three things about that moment. First, he's over him for 2 seconds. It's not clear exactly what he's doing in that moment, but even if he was searching in that moment, he doesn't take anything. So at most we have is an attempt there. We need this third woman's actions to tie him in. And then
Connect his attempt at rifling through with the then subsequent actions of the two women he is with. They're clearly together, and they're taunting this young man.
Yes, Your Honor.
It's reprehensible what they're doing to him.
Yes, and Mr. Green, as he testified, he regrets his actions here. It is reprehensible, but it's an assault, and there's not enough here to tie him to the actions of that third woman, who's what we need to make out accomplice liability on this record. She is the one who, if anyone takes anything, she's the one who picks up that object from the ground. It's not those other women, it's not her.
Did your client have to know exactly what she was going to do to be culpable for her conduct in light of what we see on the video that is clearly a joint tussling of this man of clearly limited capacity? I mean, they're taking advantage of this young man who doesn't even know what's going on.
He doesn't know what's going on, but Mr. Green and this woman do not share an intent. And I would point this court to your decision last year in Koch, where mere presence at the scene of a crime, even with knowledge that that crime is taking place or some sort of association with the perpetrator, That is not enough to establish accessory liability, and that's what we have here. He does not know.
Facts in Coke are very distinguishable from what we have here, right? Because Coke, we didn't have people together as a shooting was occurring, right? That's a case you're talking about, right?
Yes, Your Honor. And I'm not trying to compare the facts, but just the standard for accessory liability from that case. And here, there's nothing, that's not enough to link Mr. Green's actions to that woman. She's behind him as he's beating up Mr. Matos, and it's not until after he finishes his actions that she comes to the scene.
Yeah, but we have to take into consideration the totality of the circumstances. That is, how the three of them, in essence, approach this young man, how they accost him, grab him, sort of like try to go through his pockets. Then he walks away, and then he gets attacked. And then they go and they search his pockets. So when we look at everything, and we're not jurors, but the jury looked at everything, and the jury decided that to them it showed that they were all they all had the intent to take his property.
And even this court has weight of the evidence jurisdiction. It can look at this video independently of what the jury decided, and even the jury here had serious doubts. They asked twice for the definition of accomplice liability, and then asked again for what the definition of importuned meant.
So clearly, they deliberated seriously on the issue. Why should this court usurp their function and their role?
District Court. This court should look at this video, see that there's not enough.
We have.
Yes, and I appreciate that, Honor. Focus on those 2 seconds, which is all that connects Mr. Green's actions to that woman, and see that he is then taking a step back. He's disclaiming any intent to take anything at that point, and he
doesn't walk away. He doesn't leave while they're trying to rob him. He stays there. So how do we perceive from that what the jury didn't perceive from that?
Yes, Your Honor. By the time that that woman picks up that object and as this court said, rifling through it, by that point he's left. And the court recognizes that when it sustains the questions, the line of questioning, asking Mr. Green about what was happening with the object they claim was the wallet. So by that point, by the point that there is perhaps a taking, he has left the scene.
Left the scene completely.
He was there when she started assaulting, and that under Coke is
we can't
mere
see it in the
association.
video at that point, right?
Yes, and there's no evidence, no record, no testimony by anyone that he stayed around. And I would ask this court to look again at the video.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. To find that the defendant was merely present during this robbery, you'd have to find that this was some completely unconnected series of coincidences. And I'm glad that Your Honors watched the video because the video clearly shows that the defendant acted together with the 2 other women who initially accosted the victim in this case, and that he was not merely present during that accosting. When the victim tried to leave, it was the defendant who got in his way, who stopped him from doing that, and then it was the defendant who was the primary assailant of the victim. So to say that he was merely present or that this is some case of guilt by association, I think is just belied by the video that Your Honors have seen, that the jury obviously saw. And it was one continuous series of events, beginning with when those 2 women accosted the victim and culminating with when this 3rd woman came along, and she obviously was connected with all of them, judging by the way that she appeared, that she followed right behind the defendant as he assaulted the victim, and that she immediately stomped on the victim too and grabbed his wallet and then went through it with the other two women who had been with the defendant in the first place. So if there are no questions from your honors, I ask you to affirm. Thank you very much.
Thank you. Counsel?
So this is not a series of continuous events, but there's these two, Mr. Green's actions, this woman's actions, and under accomplice liability, we need either soliciting, requesting, commanding, importuning, or intentionally aiding. That is not here. And to go back to that moment where Mr. Green is over Mr. Matos, that 2-second moment, even if this court were to find that he was trying to find something on Mr. Matos at that point, it would be the weed. And there was testimony, the drugs. There was testimony that that is what Mr. Green was trying to get back. And even Mr. Matos testified that Mr. Green asked him, "Where's my shit at?" before he punched him. And under this court's precedent, which we've provided to the court, a intent to retrieve one's own belongings, here, Mr. Green's marijuana,
Did
would
the
not
video
make
show?
out.
Did the video show Mr. Matos buying or getting anything from any of these women, or him giving him any of these women money for something?
No, it does not show any.
So where does the belief that somehow this young man has something that belongs to Mr. Green comes from?
Yes, and Mr. Green explained at length in his testimony how he believed he handed to one of the women the drugs, and she was supposed to give it to him. And even a mistaken claim of right is enough under Harrison.
And this is all something that the jury was able to. They're hearing Mr. Green, they're weighing his credibility, and they're looking at the video, and they can say, well, we don't buy what he's saying, and we buy what we're seeing with our eyes in terms of what happened here.
Yes, but where there is multiple interpretations of the evidence, that this is a separate basis for Mr. Green's intent, this court can reach a different conclusion under its weight of evidence review than the jury did. And so based off of these facts, based off the record, we'd ask to reverse.
Thank you. Rivka versus Bronx Lebanon Special Center.
May it please the court, Frank Winnick, Amity Demers, and McManus for Bronx, Lebanon. As to the plaintiff, since the activity that day was merely stockpiling materials for later use, that is not covered under the labor law. It is not an
What
act.
case law says that? What case says that if a construction site is receiving materials, that the act of storing that materials and an accident happens doesn't fall under the labor law? What case says that?
Got a bunch here.
Because I've been on cases where materials are being delivered, they're not going to be utilized that day, and we have found 240. So I'm not sure where this argument is based.
Counsel didn't mention, opposing counsel didn't cite any such case.
Well, I can tell you we do our own research, and I've sat on cases where, okay, materials are being delivered. One was on a dolly. The dolly tipped over on a ramp and fell on the worker. That was considered a 240 sub 1 case, and the height differential wasn't even great.
Well, I've got Harnish versus City of New York that I cited in the brief at page.
But your cases are distinguishable because that's stockpiling material for later use. In this case, this was receiving material for use right then and there.
No, absolutely not. And that was the clear testimony in the record.
Counsel, you know, we also have evidence that plaintiff and his co-workers, they were already working on the roof 2 months prior. The day before the accident, working on,
They were prepping the roof.
yeah.
And if they had time that day, they were gonna work on the roof.
No, absolutely not. That is not even what the plaintiff testified to.
So counsel,
The cases that you are referring to, it's really about stockpiling the materials for future use, not for later use. It's getting a bunch of things together so that you have it in the event that you need it in the future, which is very different from what we have in this case.
Your Honor, I don't believe so. They've,
Also, these materials were being hoisted to the roof
yes.
where the work would ultimately be done. So what are we
Yes.
talking about?
The fact that when materials are delivered is not an activity protected by Labor Law 240.
All right, let's assume that we disagree with that point.
Yes.
What else do you have?
Okay. Plaintiff failed to identify the absence or inadequacy of a safety device that caused the accident. That there were straps that were used
Right.
to have the material. The straps didn't break. They
Yeah,
didn't,
but they got caught when they should have just slipped off.
Well-
And it was the buckle getting caught, right?
Yeah.
That caused him to have to try to maneuver it free, and then the accident occurs, right?
yes.
counsel, I think the testimony is not what you said. Look at page JR 811, and question, you weren't going to work with material at that day? Answer, after we delivered them, if we had time, take off the plastic and wrapped around it and start the roof work. So he testified the opposite. He testified that he was going to go do the work. He couldn't do the work because then the accident occurred. Look at JR 811.
On reply, I will get you the paragraph that I'm talking about. Let me, since I see that time is an issue here. The fact that the buckle got caught was not the result of a safety device that was appropriate under Labor Law 240.
But did it work? Did that safety device work to protect this worker? That belt is a safety device because it holds, right, the load onto the pallet, right?
Yeah.
And so if they can't remove the pallet and they can't remove what's holding the items on the pallet together, it is that misfunction, that buckle getting caught on the pallet that causes the pallet to shift and then fall on him.
Okay. I'd like then to move on to the common law indemnity claim against Allied. Now, Bronx, Lebanon has only vicarious liability and was free from negligence. And what it had to do was to show that Allied had some negligence. And it is uncontested that Allied failed to wait for a signal from the roof before they lifted the belt up again. It had nothing to do with Bronx, Lebanon. Allied also had the sole responsibility to decide how many belts were used and how they were lifted up. Again, nothing with regard to Bronx, Lebanon. So there is literally uncontested evidence of Allied's negligence. Allied had argued in their brief that
All right,
really
so because your time is up, you'll have time on rebuttal, and we'll get to that. You can tell me all about that on rebuttal, all right? Yep. Who's next? I think that's you. You gentlemen sat down. I didn't pick the chairs, you did.
I will do it.
Okay. Go ahead.
May it please the court, this is Ioannis Ipsos. I'm the attorney for the third-party defendant, Flutterian. I'm not going to bother the court with whatever it is in the record, but my client was the employer of the plaintiff.
Okay.
My client is a small roofing company, 3 or 4 people at the time. Allied was the supplier of the materials. My client has brought into this action, and as an employer, we understand that he has workers' compensation, and, he has done his duty, so to speak. Now my client is in this litigation because Allied, the supplier, claims that in the back of the invoice, in a letters that few people can read it, is an indemnification clause.
Right.
No, it's like we order from Amazon, and somebody is delivery, so Amazon can come. If I order Amazon can come to me and say, "Well, you're liable because of this guy's fault." So, and in this case, Ally is a huge company. My client is a tiny roofer, and he was not aware of the tiny letters that it was in the back of the invoice, and now he's in this litigation. That's really the gist of my position here. And it's, I think, as a public policy and in interest of justice, I urge this court to reverse the decision of the lower court and get my client out. Thank you.
Good afternoon, Your Honors. My name is Edward Pavia for the plaintiff respondent, and while it's an immense pleasure being before you, I'm prepared to forego my time unless any judges have any questions for me.
Which client are you?
Plaintiff respondent.
Plaintiff respondent. You have any questions? No?
Nope.
We're good.
Thank you.
May it please the court, John Cookson for Allied. I won't go that far, but I will say just two things.
All right.
As far as Bronx Lebanon's argument, we have to remember, I have not achieved summary judgment here. The trial court found a question of fact. The trial court found Bronx Lebanon, as a matter of law, was not negligent because they weren't there and so on and so forth. The question is then...
They're in here statutorily.
That's correct.
Right.
And so what they're arguing is they're entitled to a finding of summary judgment on the common law indemnification claim against Allied, but the trial court found not so fast. It's still a fact question whether Allied was negligent on the day of the occurrence, or whether they were exercising sufficient supervision and control over the operations so as to be.
But how would that change their position anyway?
It doesn't change the finding that they weren't negligent. What it does do is to say that it's premature to give them summary judgment before a fact finder has determined that Allied was negligent.
Why is it premature to say they're entitled to summary judgment because any liability they have is on strict liability basis, and should there be a negligence finding on Allied, then you have to indemnify.
You're saying a conditional indemnification, which is effectively what they argued. I'm just trying to say that Allied's not the only other actor here, and I think that it's premature to say that they're entitled to, the whole concept of contractual or conditional indemnification is sort of nebulous to begin with. It still awaits a fact finding.
Of course.
So whether you call it and give them contractual...
We would still have to wait to see what the jury decides in terms of what percentage to each party is negligent, et cetera.
Okay. And as respects Mr. Sipsis's client, who we brought in, our argument is that the invoice and the terms and conditions on the invoice are clear. They're unambiguous. This is not a general obligations law governed.
If you can read at a 0.4 font.
If you go back, and I can't give you the page, but
I don't know who can read a 0.4 font, but
I know you and I maybe not so easily anymore. But speaking for myself, okay, let's just speak for myself. The witness who said he had trouble seeing it was mainly because of the quality of the copy as much as the type. But in any event, we're saying, for the reasons in our brief, I won't go into chapter and verse about it, that it's an enforceable agreement. It was a fact question for the
Did they know about this disclaimer in the back of the invoice?
Did he know about it?
Well,
There's evidence that there was a course of dealing with this particular customer, and this was always on every invoice that they did. Did they have a separate conversation about it? I don't believe the record bears that out, no.
Okay, thank you.
Okay, thank you.
All right, and you have 1 minute on rebuttal.
That's all I need.
Okay.
All right. Great. I apologize to Justice Hagler. I cannot find the provision. It is in my brief where I cited what they had said, and I do apologize for not being able to pick it up now. Since counsel for Allied has basically conceded that conditional summary judgment is appropriate, again, they were the ones who were in charge of the way the matter was lifted. They were the ones that started to lift it up before they got the signal. And so, at a minimum, I should get conditional summary judgment. I think the council agrees.
Okay, thank you.
Thank you, Your Honor.
G Builders versus Eden Ballroom.
Good afternoon, Your Honors. May it please the court, Scott Horn, counsel representing the appellant Carlos Seneca in this matter. It's our contention, Your Honors, that the motion court erred in denying Mr. Seneca's vacatur motion, as he was represented by counsel at all times, and the default was through no fault of his own. This court has recognized time and again that the neglect of counsel should not redound to the client's detriment, which is precisely what happened here. Moreover, the lack of evidence supporting piercing the corporate veil militates in favor of vacating the $2.5 million judgment that was entered against Mr. Seneca personally. Given the strong public policy favoring adjudications on the merits, we respectfully request that the order should be reversed.
It seems to me, based on the timeline here, that there was a strategic decision made by counsel because there's no response to continuous outreach by plaintiff's counsel with respect to the inquest. The inquest gets adjourned once to give you guys an opportunity to appear, and still no response, and you fail to appear at the inquest. The court issues a decision almost 6 months after the inquest, and lo and behold, not even a week after that inquest, there's an order to show cause to vacate the inquest. That tells me counsel had been watching this case the whole time. So why should we vacate this inquest in light of that history?
I would argue, Your Honor, that the adjudication should be governed by two precepts that run through the line of cases that we cited: Rosario, Kapoor, Marine, and Aegis in particular. And the recitation that Your Honor just outlined does not implicate the individual, Mr. Seneca, at all. What these cases stand for is twofold. Even if the court is not happy with counsel's conduct or the claim of law office failure, the counsel's neglect should not redound to the client's detriment, particularly to this extent, with a $2.5 million judgment entered against this individual personally. And the second thread that runs through this line of case law is the strong public policy favoring adjudications on the merits. So those two threads.
That's why you answer. That's why you answer. That's why you file your responsive papers. That's why you engage in litigation. You don't sit on your hands, let the case go forward, wasting the court's time and judicial resources, only to say, oh, give me a do-over. Oops, I forgot. Oops, I didn't see that.
I understand,
Right?
Your Honor, and I
You'll
see.
have time on rebuttal.
Thank you.
Please, the court. Michael Gassi for plaintiff, respondent, G Builders. First and foremost, thank you for my 2 minutes. Simply put, anybody here who has practiced before the lower courts understands how difficult it is to obtain order striking an answer. It requires major willful and contumacious behavior by the defendant, which we believe happened here. And I certainly agree with Your Honor's characterization of what happened here, where they weren't paying attention to the case and then suddenly were. So unless the court has questions for me, I can rest on my brief.
Thank you.
Also, there's a pop filter that was from the microphone that's down here. Should I replace that?
Give it to the officer, he'll take care of it. Thank you.
I hope I didn't do that.
No, you didn't.
Just don't put your lips next to it. Okay?
We'll move it out a little bit.
Yeah, I don't, you know, terms and everything.
Very quickly, I am sensitive and understand the points that Your Honor was making. I would just shift the conversation back to the concept that this is the misconduct, okay, the neglect of counsel, not the neglect of Mr. Seneca. And just one last point that I'd like to make, replying to the respondent's presentation. When we're referring to the difficulty of getting an answer stricken, it was done on default. So it wasn't that difficult at all.
On default for failure to provide discovery, not because he didn't answer. He answered.
No, he did answer. It was a failure to oppose the motion, is my point.
Well,
And that's what they were looking to do.
yes, but they moved to strike because he failed to provide discovery.
That is correct, Your Honor. There was a motion, but it was granted on default. So there's never a finding on the merits of willful contumacious conduct. It was granted on default.
Wasn't there two, I'm sorry, wasn't there two episodes where I think your client was found sanctioned for conduct related to
In another case, I believe that there
not in
were-
this
there were
case?
No, I believe that's a different case, different
misunderstood.
index number.
Okay.
Thank you.
Thank you, Your Honors.
No, sir, rebuttal.
I thought it was this case. I thought he was sanctioned in this case.
Ramon versus Frey.
Yeah, I think he was sanctioned.
Okay, you can come to the mic. Ma'am, you could come to the mic.
Good afternoon, Your Honors. Karen Winner for Appellant David Fry. This case is actually straightforward, and it boils down essentially to jurisdiction. Facts and law apply. In this case, plaintiff Linda Cummings Ramon brought an action against David Fry that started out with a arbitration to remove him as director of the company. What happened was that the arbitrator only had the contractual authority to decide to remove him pursuant to the shareholder agreement, section 1F, and that's in the record. Any broader claims, such as past wrongs like breach of fiduciary duty or any other broader issues, were reserved in another part for the AAA, American Arbitration Association, in another part of the shareholder agreement. So this arbitrator that was hired was simply, explicitly, exclusively hired to decide deadlock issues, corporate governance issues,
And wasn't Judge Scheinlin noticed about a deadlock issue in April of 2023?
Absolutely. And
Okay.
in June of 2023, the respondents came to her and they asked her to make the breach of fiduciary duty issue at the centerpiece of their claims, involving a book that had a movie option, to be treated as a deadlock issue, internal corporate governance issue. She looked at it, she addressed it, and she said, no, I don't have the jurisdiction pursuant to the shareholder agreement. And her decision was June 8th, 2023. Look at the record, page 102, paragraph 5.
Right, but the basis of her determination was removal of Mr. Frey as a director based on bad conduct, right?
That was a separate ruling that she, yes, and that was a separate ruling she made December 5th, 2024. A year before, the respondents wanted her to treat breach of fiduciary duty as a deadlock issue. She said, no, you have to go to a different forum. You have to go to the AAA or the court because I don't have jurisdiction over that. I don't have jurisdiction over that. She was
Do I have a
contractually limited.
transcript of what you're saying?
Yes, it's on, yes.
Yes, where?
It's June 8th, 2023, decision on disputed deadlock events. See the record. It's page 102,
Okay.
paragraph 5.
Right.
And then she says,
What's
yeah.
the legal import of what you're reading to us right now? What does that have to do with the issues before us?
because of the case Cypress Group Holdings v. Onyx Corp., which this court decided in 2018, a finding of liability can't be precluded when the arbitrator or neutral doesn't have contractual authority. It's considered not adjudicated within that proceeding, and that is the holding, and it's binding. Cypress Group Holding v. Onyx Corp., it's in the record. So what happened is she found that David Fry was, that he had.
That he violated his fiduciary duty.
No, she found, no.
No?
She found that he should be removed because of being negative and because of being disruptive.
Right, and that conduct would support a finding of breach of fiduciary duty, right?
No, because the issues aren't identical.
The judge found that the plaintiff had proved by a preponderance of the evidence that Frey had breached his fiduciary duties, specifically that he was antagonistic to plaintiff and could not work cooperatively with her on Zonshine.
That's right. That's one component of breach of
You just
fiduciary
said that she
duty.
didn't say that and
I'm
that she
sorry.
didn't find that.
She-
So
that's-
please be clear about your arguments, okay? Because you've just misstated the record.
She didn't find, okay, so.
I just read it.
The problem is that she used the same language that one uses for a tort of breach of fiduciary duty.
Counsel, you can make your arguments about your perception about what you think the judge's words mean, but you cannot change what the judge actually said. Okay? You'll have time on rebuttal. Your time is up.
Sure.
Good afternoon, Your Honors. Adam Mandelsberg of the law firm Perkins Coie for the plaintiff respondent, Linda Ramon.
Counsel, if I may, certainly the issue before Judge Shineland was the removal of Mr. Frey.
Yes, Your Honor.
And actually, Mr. Frey, in opposing that, urged Judge Shineland to focus on New York law as related to breach of fiduciary duty.
Yes.
And there are a number of indications in the record, page 233,
I believe
254, 260, and 268, and 270, where there are specifics as to why he didn't breach the fiduciary duty, because certainly he admitted that he did have a duty to RPI, right?
Yes, Your Honor. He conceded that in live testimony in the course of a 4-day proceeding before Judge Shindlin.
Yeah, so why wouldn't collateral estoppel apply?
It clearly applies, Your Honor. And Justice Kennedy, I believe that you were referring to record pages 216 to 218 in Mr. Fry's own post-hearing briefing, in which he urged Judge Shindlin to adopt the New York tort definition of fiduciary duty and to assess that standard. And Judge Shindlin did so in deciding whether removal was appropriate under Section 706 of the Business Corporation Law. I believe, Your Honor, that that's dispositive. And unless there are any further questions, I'd be happy to rest on our briefing.
Thank you. You have 1 minute.
I thought I had 2.
Okay.
Okay, So
Yes, two, you're right.
findings of conduct that are improper or even harmful are not the same of findings that conduct is proximately causing compensable legal loss. And without a determination,
Court found that he disclosed confidential RPI financial information concerning the sales of shares without the consent of the board. That he developed a movie, I Slept with Joey Ramone, without the consent of the board. That he refused to agree to plaintiff throwing out the first pitch at a Mets game under the name of Linda Ramone, without any basis. That he engaged in disruptive and counterproductive actions against and towards the RPI vendors and partners, etc.
that's right. And that was conduct warning removal as an internal governance dispute under BCL 706D.
Right.
She said on page 284 of the record, unlike many cases, this case only has one issue that's to be decided, whether he should be removed from his position as director. She said on pages 317 and 318 that fiduciary duty was not necessary to the findings of removal. She said that on page 317 and 318 of the record. And we know that under collateral estoppel, the issues have to be identical. And even disregarding all the other arguments, and I think it is dispositive the fact that she didn't have the jurisdiction under her contractual limited authority, the issues weren't identical because the findings of misconduct, warning, removal aren't the same findings to satisfy the element needed to find breach of fiduciary duty, including adjudicating proximate cause and compensable loss. And the issues aren't the same, and without the issues being the same, liability, there's no liability, collateral
Counsel, your time is up. Thank you. Chang versus 37 Plaza LLC. Okay. Counsel, you may proceed.
Thank you, Your Honor. May it please the court, Matthew Cuomo on behalf of the appellant Ramsey Design. There's two issues in this case, and I'd like to go to the second one first, which is the issue of Labor Law Section 200 and the common law indemnity claim. Your Honor said something, Justice Manzanella, you said something a couple of arguments back. You started out telling somebody, your client is in here statutorily. And that is exactly the potential for my client. So although my client continues to maintain that it was not the general contractor and did not move for summary judgment on the 240 claim because it wasn't the general contractor, because there's ample evidence both ways as to what my client's role may have been at the time of the incident. Was it a general contractor, or was it just a carpenter or a carpentry company doing some work on the sixth floor?
We have a contract that refers to your client as a GC, right?
And that,
yes?
yes.
Yes. And we have his own testimony that he was the GC in multiple places.
No, Your Honor, that's
not.
not.
Yes, yes.
His testimony was that they were the general contractor for floors 1 through 5, which were completed by January of 2019.
Does the contract reflect that?
Yes, the contract.
The contract says you're the GC for floors 1 through 5?
The contract says for the construction of a 5-story commercial building.
Okay.
And
then there was a decision to build another floor?
There was a decision to build another floor.
And stuff like that happens all the time in construction contracts.
Yes.
Right? That there are change orders, and this happens all the time. And so there was a change, and you're saying that you ceased being the GC?
Well, by the owner's determination, my client bid for that. It was called the Phase 5 work for the 6th floor. My client bid that to be the general contractor, and the owner did not give them all of the work. They gave them just the carpentry work on the 6th floor. Essentially, by that time, they're no longer the GC. But I'd like to
Counsel, what about 439? Because, and I'll just read a part of it.
Page 439.
Yeah. My recollection, I'm just going to read the answers. My recollection is Phase 5 started in January of 2019 and ended August of 2019. And then also, there is no Phase 6. And another answer that even though the scope may have been different, but yes, it was continuously there. Yes, this is your client.
There's no dispute that my client was continuously there, that they started immediately on Phase 6. They started building the 6th floor as soon as they were done, but they were only doing the general carpentry work there.
Counsel, I have a question. As they're doing the general carpentry work, was there any other work taking place in the first 5 floors of the building other than the work that H Point was doing? Was there any like punch list work taking place?
There may have been some punch list work, but there was no significant ongoing construction.
But there was punch list work.
There may have been. The record is not clear on that, Your Honor. But I'd like to move to the Labor Law 200 because I think this comes back to, and I see where the court's going on this, I still think there are issues of fact.
Never, believe me, you should never assume anything based on our questions. You really shouldn't, okay?
But I understand, but for purposes of this argument, let's consider my client to be the general contractor. My client is only here then statutorily. As a general contractor, would be responsible under 240 and 241-6. What happened here is we also moved for summary judgment on the 200 claim and for common law indemnity against H Point. Because, one, there is absolutely no dispute that under a means and manner type of labor law section 200 claim that my client did not direct and control and supervise the H Point work that was underway at the time of the incident. The two witnesses, the only witnesses we have to the accident, Mr. Goma and Mr. Hossein, say this is all H Point, it's all Mr. Coe, we're doing this work, nobody else is doing this work, the equipment is all our equipment. So there's no means and manner 200 claim. The court went to a claim of you might have been supervisorily negligent. Well, that violates McCarthy against Turner. Merely by being a general contractor, we would not be responsible for we wouldn't be actively negligent. In order for a 200 claim to attach, there's got to be active negligence. The potential that my client had a supervisory role pursuant to contract is not a claim that can be pursued by the plaintiff, and it does not, it would not give rise to labor law section 200 claim. I see my time is up. I'm going to handle the rest of it on.
We'll have time on rebuttal.
Good afternoon. May it please the court, Gail Kellner for plaintiff respondent. I would like to address the issue of the fact that he is a general contractor first. First of all, there is testimony on page 439 that they continued as the general contractor. There's also testimony on page 355 of the record, which was Mr. Ryu on behalf of the defendant, where he stated that they were the GC at the time of the accident. In addition to the testimony in several places by Mr. Ryu, there is also the accident report that was prepared by RAND after the accident and was testified to. And this daily report, which is on page of the record 771, identifies each and every person that was there on behalf of RAND after the accident as a general contractor project manager. So they have actually prepared this incident report immediately following the accident as the general contractor. There is absolutely no documentary or testimonial evidence in this record to establish that they were anything other than a general contractor at the time of the accident. They were also responsible for safety on this job site. As a corollary to being the general contractor, there was a job site safety agreement with each and every subcontractor prepared by and executed by Ramsey. And this agreement was executed by H Point as well as all the other subcontractors, by which Ramsey had identified the job safety requirements on the job. So I think there's no question that Ramsey was the general contractor. With respect to the claims under labor law, section 200, I would basically rest on my brief, but I would also note that they did have responsibility for means and methods pursuant to the terms of the job safety agreement between it and the subcontractors.
Specifically, that agreement spelled out means and methods?
Well, it's listing the requirements, and I think the most interesting one on the list is, and this is on page 756 of the record, I believe, that in situations where this was directed in the job safety agreement to exterior work, but it's equally applicable to interior work, was that when there was an elevation differential involved in the work site, that they had to tie off with harnesses. And that was specifically listed in their job safety agreement. And they did testify, the Ramsey people testified that they knew the work that was ongoing by H Point involving the height differential and creating this opening in the cement flooring. They were aware of it for several days, and certainly could have been aware of the fact that they knew it was applicable where this was to external work, was equally applicable to dangerous elevation-related work inside. Thank you. If the court has no further questions.
You got it.
Thank you.
Good afternoon, Your Honors. I'm Jeffrey Kim. I represent 37 Plaza LLC. I just don't want to duplicate, but in the interest of highlighting, there was a contract between my client and RANS as being the GC, number one. Number two, there was a contract between RANS and H Point, hiring them as subcontractor. That's point two. Point three is there was a safety agreement that was required for every subcontractor to sign. And there was an agreement between RANS, responsible for the job site safety, and H Point.
At any point, was there any point prior to this accident that it was deemed by your client that your GC had completed the work and they no longer were GC and any additional work was just, they are now a sub?
No, that was strictly just one-sided from them, and I think it's in the interest of it's self-serving testimony, basically. But interesting about that line of question is that there's absence of who the new GC is after them. I mean, they could have easily said, we were no longer, and such entity was the GC. But the record is Steve.
Were they still doing any work in the building other than on the 6th floor?
I don't know whether the records bear that there were other small items, as Your Honor had mentioned, like a punch list type. They were substantially done with the work, but still there was work that remained. They weren't completely 100% done.
Because what their testimony indicates is that the job was done by the time that I think it was in January of 19 that they entered into this new agreement to do the 6th floor only.
Well, then what about the work that H Point was doing?
Well, according to what they testified to, which is in the record, is that your client got a tenant who needed to have the staircase put in between the 1st and 2nd floors. And that is why they gave a proposal for that job, and so did H Point, and H Point won out. So according to them, by that time, H Point was just the one doing the work on that part of the building.
I understand what you're saying, Your Honor, but regardless, that's a factual issue. That doesn't get him out as being the GC. So that remains. And getting to the 200, which I really wanted to get into, as well as the common law negligence, RANS they were the principal. They were the ones that coordinated subcontractors, maintained daily logs, oversaw progress in that job site. And they also had the ability to stop any dangerous activity, such as unprotected floor cutting work, and they failed to do so. So they were not absolved from negligence. As far as we're concerned as 37 Plaza LLC, they were joint tortfeasor along with H Point in the cause of the incident.
May it please the court, Michael Kazores from the Law Office of Eric D. Feldman on behalf of H Point. Your Honors, I'd like to address the 200 and the common law negligence issue. It's undisputed that Rands not only came up with the idea for putting the opening between the first and second floor, but they also drew up the plans for it.
They were the architects, right?
Yes. They came up with the idea, they drew up the plans, they even,
Is that a separate entity, Rand's Architecture, as opposed to?
It's a different company that's run by the same person. And, the witness testified, I believe it was Mr. Chang, said that, they came up with the idea and that Rancid or this affiliated architectural company came up with the plans for the work. And the witness for the owner testified that Rands was there all the time and controlled everything. To the extent that they dispute that, that's an issue of fact. Now, another important issue is notice. Nobody has mentioned notice at all here today, and Rand certainly didn't mention it in its brief. That's fatal to its argument. The claims by the plaintiff are based on both means and methods and notice. Notice has not been addressed by Rands here. And the case law, Herrero, this department held in 2021, that if you have authority to control site safety, including safety of equipment being used at the site, that at least raises an issue of fact as to notice while the GC is there supervising the work. So based on that, there's at least an issue of fact as to notice, and that has not been addressed at all by Rands. Now, given the issues of fact, the order should be affirmed. The issues of fact as to H Point's negligence and as to Rand's negligence reaffirms that they're not entitled to summary judgment on their claim for common law indemnity, and they're not entitled to summary judgment dismissing H Point's cross claims for contribution. There's clearly issues of fact as to my client's negligence. There's issues of fact as to his client's negligence, and therefore the order should be affirmed. Thank you.
Your Honors, there are no issues of fact as to my client's negligence. My client is at most here statutorily because it may be the general contractor. And for the purposes of the rest of my argument, let's just presume my client is the general contractor. There are two ways you have a labor law section 200 claim. Either means and manner, or there's a condition existing on the premises.
Means and method or defective condition.
Right. So we have here no means and manner case because the testimony from the workers from H Point are that H Point is solely doing this work. Mr. Coe is directing and instructing his employees on what to do when this accident happens. The lower court, the Supreme Court, did not use an existing condition analysis. The lower court looked at the potential contractual obligation and said you failed to supervise, and that's on the record 17 in the decision, that that my client and the owner may be supervisorily negligent. Not that they actually did something negligent, but that they failed to supervise. And under long precedent here, McCarthy against Turner, you cannot have liability under labor law section 200 because you have contractual obligations or because you're the GC and you should supervise. So that left the respondents to pivot to try and find an existing condition on the premises. And on this issue, I'd like the court to look at Delana from this court back in 2004 and Capabianca. And in both of those cases, in Capabianca, you had a wet sore, the water is going all over the place, and he slips on that. That plaintiff, Mr. Capabianca, says, hey, wait a second, there's also an existing condition. And this court, or another panel of this court, says, well, wait a second, The only reason that condition exists is because the means and manner of the work. The same thing in Delana. There's a bolt that protrudes from a concrete slab that was put there to hold temporarily a tank. Months later, the plaintiff trips over it. This court said that is not a defect inherent in the premises. It arose out of the manner and means of the work. And that's exactly what we have here. This accident occurred while they were doing this work. It is a means and manner case only, and there are no issues as to my client's, the fact that my client did not exercise supervision and control over that work. So as a result, the 200 claim should be dismissed, and we're entitled to common law indemnity.
So much. Outlaw versus New York City Health and Hospital Corporation. Last but not least.
Good afternoon, Your Honors. May it please the court, my name is Sarah Isaacson, and I'm representing the plaintiff appellant in the 2025-2215 case and the petitioner appellant in the 2025-2216 case.
I'm gonna need you to step closer to that mic so we can hear you.
Okay. So these two different appeals involve orders on three different motions. The defendant respondent's motion to dismiss, the plaintiff appellant's cross motion to amend the complaint, and the petitioner appellant's motion to renew. With respect to the motion to dismiss, the trial court dismissed it, claiming that the plaintiff appellant had not pled that there was a special duty owed to her by the defendant's respondents. But this was an error in that the determination of whether there is a special duty is something that's usually reserved for a jury and definitely not on a motion to dismiss. In fact, there hasn't been a single case cited in this case, and either by the trial court or by defendants.
Your biggest problem is your notice of claim.
We can.
You got to get past that. We can't even address the substance. We don't even get there.
Okay.
How do you get past not serving HHC?
Mm-hmm.
You cannot get around that. You can't serve another entity that is not HHC.
Yes, Your Honor, we acknowledge that it was a late notice of a claim and that the petition is for a request to file a late notice of claim. Our motion to renew is based on facts that were known at the time that the petition was filed, but were left out due to law office failure, which would have made our petition to file a late notice of claim timely. And the lower court doesn't address that. It doesn't talk about the May 2022 constructive discharge, which is a fact that is known by the defendant's respondents at the time that the petition was filed, the complaint was filed. It's not a new fact that we're inventing. She left the job at that time.
Cannot get past the lack of notice.
Yes, Your Honor, but if we are permitted to file a petition to file the late notice of claim, and that's...
The problem is the case law is just completely against you.
Mm-hmm.
And you had enough time to file this before the additional window, and you blew that too. And in our precedent, once you blow that 1 year and 90-day window.
And the details of the motion to renew, they're not before us because the judge summarily denied it. Denied that motion.
That's not appealable as a matter of right.
Okay, yeah, I mean, we believe, I mean, she did deny the motion to renew. She said that it was denied, but didn't provide the reasoning behind it.
That means it's not appealable.
Yeah.
When there's no reasoning on a denial of a renewal, you're stuck with just the original decision.
Sorry, let me clarify. She did say that she was denying it based on oral arguments and what was written in the other opinion.
Counsel, nice try. I mean, I feel bad for you because I understand your frustration. It's our frustration too. Counsel must serve the right parties on time.
Mm-hmm.
And we cannot. We don't have the authority on these facts to go around that. So I'm I'm not sure what else we can do.
Yeah, again, we believe that based on the facts that, were known to all parties at the time, that petition was timely. And we have a continuing violations theory alleged in the amended complaint, in the initial complaint, in the initial petition, which.
As I said, great frustration. Okay, let's hear the other side and you'll have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Amy McCampbell on behalf of the respondents. Your Honor, just a few quick points. First, as was just discussed, petitioner here failed to file a timely notice of claim against the proper party. The only thing on appeal in that regard is her motion for leave to renew, and that motion was filed outside of the time in which the court could grant the relief that she seeks. We cited multiple cases for that point in our brief. She has no response to that. So on notice of claim alone, this case cannot proceed. Second, to address the special duty point, I heard counsel just say that we haven't cited any cases in which special duty was decided on a motion to dismiss. That's incorrect. We cited at least 2 cases in our brief, the Velez case and the Holman case, both from this court, in which this court granted dismissal for failure to plead facts that could establish a special duty. And third, I'd just like to respond to a point that petitioner focused on in the reply brief. In the reply brief, petitioner tried to make hay of her allegation that one of her harassers was allegedly transferred to a different building. She says, oh, that could show that the employer was taking action on her behalf. However, her own complaint repeatedly pleaded that the defendants did not transfer anyone in response to her complaints, even though they had the power to do so. And that's page.
So if this case had been filed on time, you'd be going to trial, okay?
We asked this court to affirm dismissal.
'Cause
Thank you.
The allegations are outrageous, and the lack of any action on the part of her supervisors, doubly outrageous. But the law is the law, and they didn't get their complaint in on time.
So we asked this court to affirm dismissal. Thank you, Your Honors.
You have a minute.
Nothing further from us. I just ask that
Thank
reverse
you.
the decision.
Have a good night, ladies.
Jesus, you all right?